Judge Messer, can you hear me?
Can you hear me?
Yes. Carl, can
Good.
you hear me?
Yes, good morning.
Good morning. We have a few people who might not be here till 9:15, so we might just start a little bit late if that is okay.
That's
Okay.
fine. I'll keep my video off and I'll have my breakfast. It's 7 a.m. here. I'm in California.
Awesome.
Not really.
Uh-oh.
I'm I am a caretaker for my 94-year-old aunt, so I'm out here about every 6 weeks,
Yeah.
and I'm staying in her house that hasn't seen proper maintenance in 30 years. So the Wi-Fi might be iffy and
Right?
but but we got through all the medical and banking appointments, and
Yeah.
Hi.
she's securely back at her house, so at
Oh,
her
good.
board and care
So
facility. And
just so you know, we are streaming on YouTube. I
okay,
just made
well
it
then we
private
will.
again.
Thank you.
Yeah, that's so
Yes.
hard.
So I'm
That's hard to
gonna
take
pause
care
the
of aging
streaming
parents.
until we officially start.
Okay, and I'll just mute and wait quietly. How about that? Um, I think I'm gonna leave my video off because of bandwidth issues here,
Yes.
and that will make it easier. I mean, I'll continue to be able to get the stream. So,
All right, sounds good.
all right, I'll
And
wait.
I paused the
Oh,
live streaming, so we'll turn it back on once we're officially starting.
okay. Sorry, Carly. I always forget. All right, I'll go off.
Good morning, Artika. I was just explaining to the others that because of school drop-offs, there are going to be people that are a little bit late, so we might start closer to 9:15.
Good morning. Sounds good.
Okay, thanks. I see Commissioner Graves just came online. Um, we're going to start a little bit late. I think we'll start in about 5 minutes.
Sounds good. Thank you.
All right, for all the commissioners online, we are about to start live streaming again and then record and then start the meeting.
Good morning, everybody. Welcome to the Minnesota Clemency Review Commission meeting. The date is June 5th. The time is 9:12, and we will start with the roll call of officials. My name is Commissioner Zach Lindstrom, and we would turn it over to the folks online.
Commissioner Carl Crawford.
Commissioner Catherine Messrick.
Commissioner
Commissioner-
Nadine Graves.
Good morning, Commissioner Artika Roller.
And we'll be, we're still missing a couple commissioners that we're expecting them to be in person or online here shortly. But we're going to go ahead and start moving forward, and I'll turn it over to the executive director.
Thank you, Mr. Chair. So we're going to start with just a brief overview of the clemency process. Some of these PowerPoints are going to look a little bit familiar because we went over them 2 years ago in June. But I have different context now because we have actually been doing the work for 2 years. And something that goes with these is in the shared folder, which is our sample templates. It's a PDF that I put basically an example of almost every template we use to reach out to applicants. You won't see a pardon and commutation version of everything because in some cases they are so similar. I figured I would just provide one copy. So I need to make the YouTube live. One moment.
While we're waiting, it's great to see everybody again. Hope everybody's June is off to a great start.
Okay, I think we're back. So yeah, this was in response to a question that Carl received when he was going to an event, and he realized we haven't talked a lot about what we do as staff other than prepare the summaries. You see the result of that work, but there are a lot of different steps in the process. So I'm just going to go quickly through it. When it comes down to it, there are 5 steps of the process. We receive the applications, we process the applications, we have a CRC meeting and then a Board of Pardons meeting, and then the recommendations are finalized. We have 2 types of applications, and we tend to prioritize processing these most, which is pardons and commutations, but we also have those waivers of the waiting period and permission to reapply early. Though we process those usually within about 6 months of receiving them, those we'll send them out closer to when the Board of Pardons meeting dates are, because they have to be decided at those meeting dates. So when we get an application, first we decide, or we check to make sure it's complete. We use some discretion to accept things that are not fully filled out. For example, if someone has a case number that's not correct, we will find the case number for them because we know not everybody has the same sophistication with the legal system, and it's not easy to navigate. There will be other times when someone doesn't put any case number on, and if we can find that case and the facts match, dates match, we will confirm with the applicant, but we'll do a little bit of that legwork to help with that. There are some things that we can't help with. For example, narratives, those have to be in there by the applicant. So then the next part is we review eligibility. That means we figure out when the discharge date is and see if it is eligible based on waiting periods, make sure it's a Minnesota conviction. Petty misdemeanors are not criminal convictions, so that's not eligible. Juvenile adjudications are not considered criminal convictions, so they aren't eligible. So sometimes it's a matter of logging on to the court website and looking at the records. Sometimes there aren't records, so we have to request those first. We have been trying for over a year now to get into rolling application screening. And just based on the workload and staff capacity, that has not been achievable. We still try to make sure that things are screened within 3 or 4 months of when we receive the application. But a lot of that screening work happens during the months in between the CRC meetings.
Do we get a fair amount of applications where people don't meet the requirements and or are applying for a pardon for another state?
We get a few. If I were to guess, and don't quote me on this because I'm not looking at that data, I would say it's probably 10% or less of people who are not eligible or applying for another state for whatever reason. With commutations, it's probably a little bit higher that people are not eligible, but it's less than I would have thought.
Expected, yeah.
Yeah.
So most of the people that are applying meet the criteria.
Yep.
That's good.
All right, so yeah, once we look at all of these things, then we send the applicant a letter to let them know if they're eligible or ineligible. We changed our letters towards the beginning because we used to send out a letter when they were scheduled for a hearing, but we realized there was too big of a gap between when we did eligibility screening and when we scheduled. So currently, between when we tell someone that they are eligible and when we can schedule them for a hearing, it's probably more than a year's wait, except in those cases that are extraordinary circumstances or time sensitive. We're still trying to balance those so that as we receive more time sensitive applications, we want to make sure we have the agenda half full of applications heard by date received, because we are only through the beginning of 2025 with those that are heard by date received. Our backlog is quickly growing. This is something I will talk about a lot at the legislature. I did this year, and we will get into that more in a little bit.
And I'm assuming some of that growth is due to the recent media coverage we've had.
That is so recent that I don't know if it's related to that.
Okay. But we're receiving more and more time sensitive applications than what we had in the past.
We are, yes, and more applications overall.
In general.
Both.
So our promotion is working,
Yes.
but now we're reaching a bottleneck.
Yes. So once someone is eligible and then we schedule them for a hearing, we do the investigation. Some of this happens before they're scheduled, some of it happens after. But we request and pull court documents. That's all of those attachments that you see. We send notice 60 days ahead of time to the judge and prosecutor and at least 30 days ahead of time to the victim, as well as publish notice in newspapers 30 days ahead of time. We get letters of support and other documentation from the applicant. We accept that all the way through the date of the meeting. We'll even accept it after the meeting before the Board of Pardons. We just let the Board of Pardons know that that was not part of the consideration of the CRC. We also do background checks in the BCA database so that we know if there are warrants in other states or convictions in other states. And as you know, those are provided as well. So this isn't just outlines our victim participation options. Victims are allowed to choose whether they want to give a statement in person or in writing. We just went to the legislature to change it slightly. Previously, a victim had to make their written statement confidential to the public. There had to be an order for protection or harassment restraining order. We changed that in statute this year. So a victim can choose to have their statement confidential from the public upon request. If they want it confidential from the applicant, there has to have been some kind of order for protection, harassment restraining order, or other no contact order. So there was some compromise related to concerns about the applicant's due process rights for that provision. And what we actually do is we don't provide the victim statement. We provide a synopsis of it in a summary. And then if the applicant requests to see it, we will provide that. Commissioner Graves, I see your hand up.
Yes, often in a sentencing order, it'll say no contact with the victim. Is that sufficient, or will there have needed to be an additional, like outside, like a civic, no contact order?
That's a great question. We look at those probation orders, and often we will consider that a no contact order. For that specific condition in a probation order, sometimes we look at the context, because we also know that there are times where that is just the judge orders it in every case. But I don't know that we haven't had a lot of those where there was no contact in the probation order or the sentencing order, and it wasn't related to things that we would allow it to be confidential for. I think I'm not going to go over the hearing related, victims can have their verbal statement be confidential from the public if they request a closed meeting and the commission agrees to close the meeting for sensitive and confidential victim testimony. We don't get a lot of those requests, but that is a request that we've gotten quite a few times because the victim had fear of the applicant or the surviving family members, and they weren't able to make a private or confidential statement written because there wasn't a protection order. All right, so summary writing and sharing. I think you are all pretty familiar with this because you've read a lot of summaries so far. The legal analysts prepare the summary using a template. They get all of that information that you see into the summary. They compile all the sources into a single document, add bookmarks, and then we send the summary without the attachments to the applicant. If they request the attachments, we will send them. And then we redact confidential information for public viewing. So all of those packets with the exhibits that you see, we have a separate version that has been redacted in case someone a member of the public wants to inspect them during the public meeting. A note about confidentiality, I'll just go over how we treat confidential documents just as a reminder. So if something is in the summary and we say that confidential documents say something, usually there's a corresponding document in the confidential folder. If the document is confidential to the public, it means that the applicant likely has access to that information. If it's confidential to the public and applicant, it means that it's very, very confidential, basically. Where we see that a lot are PSIs, which have very strict confidentiality protections, and also harassment restraining orders and orders for protection that have been filed but not sent to the applicant. So if things are in that folder, they should not be discussed on the record or mentioned on the record. The other thing I want to talk about with confidential information is related to identifying information for victims. We do a really good job of identifying those cases, or Zach mentions that the victim's name and identifying information shouldn't be stated in a public meeting, and that's for cases where it might identify victims of sexual assault or domestic violence, maltreatment of a child or vulnerable adult. I just wanted a reminder that it's both the name and identifying information. So sometimes there will be a familial relationship, like this person's wife or their daughter, where a member of the public could identify that applicant through that information. So we also want to try to avoid saying those, because that would require closing the meeting.
I got a question about that. It's about I'm wondering if it wouldn't be helpful at the beginning of like when we're doing a block, like, I read that statement about this bring up many emotions. I wonder if it wouldn't be appropriate to insert a little bit of information about, because we do have a fair amount of them where we don't want to reveal that. I wonder if it would be appropriate to insert some scripting at the beginning of the blocks saying, just kind of spelling out what we don't want people to say as we move through the cases. It's a
Yes.
thought.
Yeah, we can do that.
We don't need to. I was just thinking about it because I could see it being helpful for some people, especially the identifying information part.
Mm-hmm.
That if we kind of set that as a precedent or an expectation moving into the hearings, I think that it would we haven't had a lot of it, but maybe it would just put it more in people's minds, especially when they sit down and they'll be like, oh yeah, they just said this an hour ago.
Yes, that makes sense to put a little more detail in the block introduction and then just have the warning at the
Yeah.
case level. Carl, I see your hand is up.
Yes, good morning. Am I still, can you hear me?
Yeah.
Okay. I'm wondering, as far as a data request, and you might touch on this, I read your email earlier, Carly. When we are doing our notes and turning things in, what all is part of a data request that an attorney can require from us?
Everything.
So any
All-
notes, minutes, anything on our notepad, or just the things we turn in?
All that is all public data, even on the notepad.
Okay.
So for our purposes, when we take your binders back, if there are notes in there that aren't official record, our practice is to clean out the binders and shred the information. So that's just because it's
Okay.
not an official public data or a public record. We don't hold on to those. So you can decide how you want to do that with your own personal notes that you have from home, but
Mhm.
everything related to the Clemency Review Commission that isn't otherwise protected, like victim data or confidential employment data, is open to the public and can be requested. So if you text on your personal phone about commission business, even though it's on your personal phone, that is still open to the public if requested. And that's one of the reasons we have the iPads so that you can, as much as possible, keep all that data on the iPad. And that's also why I have the settings turned off, I think, so that you can't download things from OneDrive, so that you don't inadvertently put public data on your personal devices.
Excellent. Thank you.
Yeah, and if anyone tries to contact you individually about a data request, please call me. I'm the authorized representative for the agency related to data requests.
Excellent. That's great to know. Thank you.
You're welcome. All right, so summary writing and sharing. Now we're on Clemency Review Commission meetings. Again, most of this, you know how it works. We anticipate about 20 pardons and 2 to 3 commutations per meeting. We've, done some experimenting with how many cases we can hear. This is approximately an 8-hour meeting. We tried doing more in May with mostly no victim offenses or nonviolent offenses, and we were able to get through quite a few more of those. The commutations take at least 45 minutes. So we're just unable to hear more of those. Something else we've run into is more on the staff capacity side. We're very close to being maxed out with how many summaries we can get done in between meetings. So we have a desire to process more if the commission would meet more, which I've heard a lot of desire to find more meeting times for hearings, not necessarily more training, but yeah. But so far we just have not had that capacity, and we're working on it. We are doing our first internship program this morning. In fact, one of our future interns is in the audience today. So we're getting those finalized to try and build capacity, but doing the actual work of the clemency process while also continuing to build the agency, doing those simultaneously has made all of the capacity building work much slower.
Just make a comment about that.
Sure.
So just a couple of things. I mean, one is I have glimpses into how hard staff is working here and there, but I think it's beyond, I think there's 6 of us here. I think it's beyond what any of us really realizes. Like I think it's, 70+ hour weeks every single week. Sorry, should I be?
That's okay. You're sometimes a bit soft-spoken.
Am I really? All right. So my family would disagree, but so I guess I just want to acknowledge that, sometimes it's easy for us to think we could come for an extra day. And I think an enormous amount of work goes into it. I think there's just a lot we don't see. And just from my perspective, you're all doing remarkably good work. The summaries are excellent. They're really excellent, and they're comprehensive. They are detailed. You glean what I see as all the important information from sometimes 1,000 pages or something like it of documentation condensed. So one of the things that I've talked briefly with Carly about is, we lack the resources to hire more staff, but are there other ways to think about doing that? I know that there's philanthropic money that is, from certain foundations to support post-conviction work. I'm looking at Kathy as well right now. So maybe those are things we can think about. I just had the same conversation with the conviction review unit folks who are also down on employee and strapped. So I just want to acknowledge from my standpoint, and I think I speak for all of us when we say, we feel really well supported. At least my ignorance at times is not for lack of effort from all of you to provide information. So thank you. And we do see it. We really do.
Thank you. I appreciate that. And everyone in our office works really hard.
It's remarkable.
So, yeah, and we are thinking about those other options, like if there are partnerships we can do with foundation support. So there were, a year ago, I think we were talking about different efficiency measures we could put in, because we were still thinking that it was a matter of, this is a new process, can we create efficiencies and do more? And it quickly became clear it was more of a resources issue. So we're trying to do as much as we can while also moving forward on some of that capacity building and long-term strategic work, which we can see the result of that in the fact that we had a legislative proposal this year. I think we'll talk more about that in the fall, because it was developed sort of late for session. It was right before session started that I got approval from the board. But it's amazing that we had such a thorough process, and we'll be ready to bring it next year.
Which is incredibly time consuming as well.
So the commission meetings, we have a growing backlog of cases. In 2025, we received 401 applications and held hearings on 164. That's just pardons and commutations. I don't count waivers and rehearings in that because they're just treated slightly differently. In 2026, I think by by June 1st, we received 210 applications. So that's a month ahead of halfway through the year. So we're already ahead. If I did some projections, and if the 2025 numbers hold steady, meaning we are able to hear all of the same cases and we keep receiving the same amount, we will have a 9-year wait by 2031, or I think it's an 8-year wait. So that is something that we're going to keep advocating to say that obviously there is a need here. So either we need more resources, or some of the statutes related to collateral consequences of criminal convictions need to be changed. Both should happen, maybe. Okay, I am a little over time, but I'll talk about how we process commission recommendations. Within 14 days of the decision, we send the applicant a notice of the CRC recommendation. In that packet of sample communications, I included the template for the cover page. So we send a cover page of the recommendation that says each individual's vote, the overall vote total, and whether a hearing is recommended or not. We don't send the individual voting forms, but we do have people ask for them. So you should know that what you write in the comments will be provided to someone at some point. All of those comments, we actually type them out for the board members. So they get a packet for each applicant that has the summary of the decision, the individual voting sheets, a summary of comments, and then the entire CRC packet.
What I will say too, but in relation to the comments that we do put out there, we've gotten so much better at that from when we started. And I've continually noticed that the board members will, if there are concerns that we've identified with certain with cases, that I've seen more often than not that the board members will ask those questions of the applicant to firm up some of those concerns that we had. So I just continue to advocate for good, strong notes like we have been doing, and let you all know that they're greatly appreciated and they're being used.
Okay, so these large packets, we try to get them done within about a week of the decision. We send the applicant letters, like the board packets don't need to be complete when we send the applicant letters, but we try to get all of it done within a week and no later than 2 weeks after the meeting. So we do that after every meeting and then ask the board members to review all of the recommendations and let us know if they want second hearings. So then there's the Board of Pardons meetings. They meet at least twice per year. Last year they met 4 times. This year it will likely be 3 times because of the Chief Justice retiring on September 30th. I don't think we're going to be able to get a meeting in before she retires. But there is one next week on the 10th. And that may change next year as well with the new board. I was happy that the board listened to my request to meet more often because there were decisions that the commission would make, and then it would be 6 months until the next meeting, or that only happened once because then they changed the frequency with which they meet. But there will likely be some changes next year based on the incoming administration and the new Chief Justice and any potential changes in commissioners. Anyone who is appointed by the Chief Justice, you can stay in your appointment until the new Chief Justice appoints someone else. I'm still trying to figure out what happens in January when your terms are up if the appointees have not reappointed. It's not clear in our statute whether you can remain in that position and we can keep meeting until they replace or reappoint. So there will be more news on that in the coming months. Okay, so for the Board of Pardons meetings, we send all of the packets to the board. We have a shared teams, kind of like the commission. We put all of the materials in there. I work with the governor's staff on the agenda, on the order of the agenda, if there are people that they want to delay or other things. Once the meeting is over, we process the certificates and file them with the court. So yeah, we try to do that within a couple of days. The processing certificates and getting them signed by the board members, we try to do that within a few days after the meeting. If there was a commutation that was immediate release, we would probably try and do it like the next day or the day of. But it still takes some time to get everything signed and do all the administrative part of that. And I also noted all records are sealed upon granting of a pardon. I think I've mentioned that before. That's been a little bit of an issue because we're not supposed to share with the applicant or anyone the applicant wants to know that they got a pardon. So that will be in our legislative proposal again next year to allow a little more flexibility. And I'm also talking to the courts to see if they can amend their order sealing and expunging the records to give us a little bit more flexibility. But we are not in recess. That was the end of me talking about our process. I'm going to stop sharing. As I said, you've got that big packet of communications. It might be too many communications, but I wanted you to see the breadth of the work we do throughout the process. It's really hard to explain how this process works to people. I was going to say who aren't part of, like, don't work in the legal system, but even for people who work in the legal system, this has many steps, which I think makes it a less political process in a lot of ways, and hopefully more stable. But it is administratively heavy. Carl.
Thank you, Carly. So I was part of a expungement clinic and asked to be there and talk about our process. So thank you so much for going over this. And I just put together kind of like a simple binder that kind of talks all about what we do and how we do it. But more importantly, the application process. So I printed out how to apply for clemency and then had some ways for them to contact and start that process. But I don't know if any other commissioners out there have had that same situation where you've been asked how to do this. And that's why I reached out to Carly, because I really didn't know. I was embarrassed to say that. I didn't know the full process. So I guess in some of these other communities, as we are the faces of people are knowing us from the Clemency Review Board, if others have had people ask them, how do they do this process?
I've had that come up pretty frequently. I really try to stay away from knowing any specifics about the case. Like, that's the first thing I tell them, and we're like, I don't want to know anything about what your charges, your case, or anything like that. So I set that groundwork right away, and then I share basic information, but most of what I try to do is get people to the CRC website. Mm-hmm. And if they're looking for additional help, mentioning, the Legal Revolution and other folks that are out there that are actually assisting people with the application process.
Excellent.
Yeah, and you can always refer them to us. We have a lot of information on our website. We have some one-pagers that I still need to put on the website, but there's that eligibility one-pager in that packet somewhere that talks about the criteria for eligibility. And I can create a shared folder if everyone would like, with all of those one-pagers.
That'd be great.
In that Teams. And the thing that I get asked the most, when it's usually in the hallway outside of the meetings, is just people are overwhelmed with the amount of information they need to provide about their criminal convictions. I tell them to do the best they can. If they can get the case number and the factual, like their version of the offense and maybe the county, we will take it from there. I also let them know they can call us and we can try and help them figure it out. We've gotten a lot of really good feedback about our agency being reachable for questions. A lot of that is John, who is the main contact for our office, and he gets a lot of phone calls and does a great job. So thanks, John. Commissioner Badherpel.
Good morning, everyone. Carl, in response to your question, I have received questions from folks when I'm out in community. In fact, just recently I was at an event at the Minneapolis Indian Center, and folks are just more and more starting to learn about the process, which is good. I will say one of the questions that I have received is how long will it take? And so that's a tough one. And I make sure to let folks know that the staff and, everyone is working hard to figure out this process and to try to get folks in front of in front of us and in front of the board, if need be, sooner. But I'm also very honest that it can take a while. And so that part of that is encouraging folks. Again, I go to the website. I think having those one pagers would be really helpful. But I tell folks to go to the website, you know, and give the give information that has been shared with us. And then let folks know to, you know, if you're interested in doing it, you want to have a comprehensive application, and just recognize that the sooner you get it in, the sooner it's going to get heard, and that it will take a while.
Yeah.
But
Yeah,
that's a
and
tough one.
Yeah, and I will add it, because we have chosen to not just use the date received, it is unclear how long things will take for any individual applicant. I
Okay.
usually tell people it can take 1 to 2 years or more. We've had a lot of discussions about whether we should just do date received or continue screening for, you know, time sensitive issues. And I think even though there would be equal treatment doing it by received date, I think it's more equitable to analyze if there's a significant impact to the applicant by waiting a year or two. And we are talking about doing a specific policy and a specific kind of like the waiver application, like a small 1-page form, so people can tell us exactly why they think it needs to be faster, like their application, and provide evidence so that it's less up to our discretion, because we want to make sure that we have all of those things covered. Commissioner Moriarty?
Yes, and we may have time to talk about this when we talk about CRC discretion. So I know Kathy's here to talk with us, so we can push it back. But I do think it'd be helpful to talk about requests for a waiver of the waiting period, in part because it does involve people effectively, you know, necessarily pushing others back. When we do grant a request, it means that someone is expedited both in front of us and in front of the board. And I know there are questions about sort of the new and substantial information requirement. I think it'd be really helpful for us to talk about that, but would it be appropriate to talk about it when we talk about CRC discretion? So we can hear from Kathy, or I'm not sure what you think.
We can. Yes, I would like to move on to talking about the post-conviction relief. We're gonna talk, about the CRC discretion, so we can talk about it
Weave
then.
that in a little bit.
Yeah, we could also schedule some time during the July meeting.
Okay. We'll see how we do with what we have on the
Yeah.
agenda and see if there's time.
Yeah.
Okay, great.
We can always meet later than the stated end time as well.
Okay, thank you.
All right, I'm really excited that Catherine Millbrook, the appellate chief public defender, is here to talk to us about post-conviction relief. Back 2 years ago, again, we talked about this commission, or this discretion that the commission has to deny commutations without a hearing. And one of those factors for which it can be denied is if the applicant has not exhausted all of their remedies. But what exactly does that mean, and what remedies are available? If they're technically available, are they practically available? And there's a lot of questions like that. So we'll talk more about that later.
I've got a flash drive, or I've got it on my computer. I've got a PowerPoint. Do you want to?
I'll take the flash drive. I will share that, and you can just say next slide when you.
You can, sometimes you have to click it to get the rest of the information up. There you go. So, I'm Catherine Middlebrook. Most people call me Kathy. But I am the Chief Appellate Public Defender. So, my office does all of the appeals and post convictions for any indigent defendants statewide. So we're a statewide office. We get everything after a defendant has been convicted and sentenced. So I'm going to talk a little bit, you can go to the next slide. I'm going to talk a little bit about kind of what I want to talk about different avenues for a defendant to challenge his conviction or sentence pretty briefly, a little bit about the direct appeal process, and then about the post-conviction process, and including in that the different limitations that there are, some other procedures that will provide post-conviction relief. I'm going to talk about time limitations and then the exceptions to those time limitations. And if you have any questions, just feel free to ask me questions as we go. So you can click again, Carly. So like I said, we do both appeals and post convictions, and both of these are avenues for a defendant to challenge his conviction and or sentence. And we do appeals for both tried cases or guilty pleas. And the reason, Carly, the reason that you might wonder why guilty pleas, why would somebody appeal a guilty plea? Why would they seek post-conviction relief? In Minnesota, every defendant has one right to review of their conviction or sentence. So that's why they're both tried cases and plea cases. And there's often issues that will come up on a plea case, whether or not it's an accurate plea, whether or not there's a complete waiver of all the defendant's rights, whether the plea agreement was followed. So there's a lot of things that some will come up with plea cases as well. And so that's kind of the overall how to challenge that. Okay, next slide. So as of right, a defendant can appeal from the final judgment. They can also appeal if they filed a post-conviction and lost at the post-conviction. They can appeal that to the Court of Appeals or the Supreme Court. They can appeal their sentences, and that's only in felony cases. They can also appeal a lot of other orders that probably are kind of irrelevant here, but that's where they have their appeal of right. Next slide. So on the direct appeals, that's all governed by the Minnesota Rule of Criminal Procedure 28. And it goes over the two different sections on appealing by a defendant, and then sentencing appeals has a different kind of process because it's more of an expedited appeal. And then all of the cases that go to the Supreme Court are governed by Rule 29, and they're very similar to Rule 28, but they have their own process. And as you probably know, all murder one cases go directly to the Supreme Court. They bypass the Court of Appeals and they go directly there. The PFR grants, that stands for Petition for Review. So that's if a defendant loses at the Court of Appeals and they file a petition for review to the Supreme Court. It's a discretionary appeal. And the Supreme Court, they don't grant very many of them, but they're usually issues that there's a really like statewide issue. It's a really significant issue, important issue. So it's a pretty low number that get granted on those discretionary petitions. And then there's also these cases that will go to the Supreme Court on accelerated review, and they will also then bypass the Court of Appeals. And sometimes they're just a really important legal issue that's affecting a lot of litigants, that's affecting, that needs to be decided right away by the Minnesota Supreme Court rather than the normal process. So those are how the criminal cases get to the Supreme Court. So with appeals, there's a very, very tight time frame. So a direct appeal on felony and gross misdemeanors is 90 days from when the person is sentenced. It's 30 days for a misdemeanor, so that's really quick. Post-conviction appeals, that is 60 days. So those are the kind of the timelines. The appellate process is very lengthy. we advise our clients that from the time that we get their case right after they're sentenced, it's probably going to be 9 months to a year before they get a final decision on that appeal.
Are you okay with questions?
Yeah, absolutely.
Can you talk about whether their applicants are entitled to court-appointed counsel
On appeal,
and when they're not? Yeah.
yeah. So on a direct appeal, anyone who is indigent and qualifies for the public defender has the right to a public defender on appeal. Otherwise, a criminal defendant, if they don't qualify for a public defense, if they're not financially eligible, they would have to hire private counsel to do their appeal, or they can file it pro se, meaning they'll do it themselves. But there is not an absolute right to counsel unless they're indigent.
And what about post-conviction? So what about, for example, an innocence claim or?
Yeah. So, and then down the road here, I get a couple of slides there, but on yeah, it's okay. On post-conviction, it's the same thing for my office. If they have not had a direct appeal and they contact my office, for instance, if it's too late, they missed the timeline here, then we would represent them on post-conviction because they have never had a review of their conviction and sentence. So they would qualify to have counsel appointed from my office to represent them on the post-conviction. If they've already had the direct appeal or they're not financially eligible for a public defender, then they would have to hire private counsel or they would have to represent themselves pro se. There are the Great Northern Innocence Project. They will take cases on post-conviction. They have a pretty strict criteria that they will look at, that they will then go in and represent on post-conviction, but otherwise they do have to hire private counsel.
So we see a lot of people that have an extensive post-conviction history. And I just want to make clear to the other commissioners, it doesn't mean they've been represented in all of those cases. So there are going to be a lot of pro se filings that may be time barred, and we see a lot of time bars. We see a lot of,
Yeah.
So even though it looks robust, it does not necessarily mean the filings have been robust.
Right. And in those cases, I mean, I think they've had one either appeal or post-conviction represented by counsel unless they didn't qualify.
Exactly.
So that's true. And some of them do file multiple post-convictions.
Oh, yes.
So as staff, a lot of times we will see that there is an appeal is filed. There aren't necessarily grounds, and then it's voluntarily dismissed, but it's a representation by the public defender. Are those cases in which there may not be a legal argument?
Yeah, so particularly on the guilty plea cases and a few tried cases as well. Once, we've started the appeal process and, you can see the timeline is 90 days goes really fast because a lot of times, especially if they go to prison, they're going through intake, they're kind of, dealing with a really difficult time in their life. And they're not really thinking time. This is the time element. I need to contact the appellate office to appeal. And when they do, it could be, just within days of that notice of appeal being due. So we file the notice of appeal to protect their right to appeal. And then we get the records and the transcripts and review it and discuss it with the defendant about what issues there are or aren't. And sometimes, on a plea case, there aren't any issues. Everything was, the plea looks good. It meets all the constitutional requirements. The sentence is what they agreed to. And they mostly just wanted someone to review it and see what they thought. And so we kind of advise them of risks if they go ahead and they're successful, and what they want to do. And if they decide they don't want to go ahead with the appeal at that point, then we'll file the voluntary dismissal. Down the road, they may decide, I want to appeal or I want to challenge it again. I mean, that does happen. Tried cases is somewhat the same. But if they have a relatively short sentence or they're going to qualify for one of the early release programs like CIP, they don't want to keep going on their appeal. Even if we've advised them, you do have a meritorious issue. Because they look at, I want to do this, I want to, go through this program and get back out to my family and the community. And so, later they may decide I'm going to challenge this because of the collateral consequences of that conviction. So that sometimes, we see both of those situations. You have a question?
I do. Just tell me if you're going to address this later. When would someone seek post-conviction relief versus as opposed to a direct appeal?
Okay, yeah, I think that might be the next one.
Okay.
It's a great question.
Yeah. So with post-conviction, when we would file post-conviction is, first of all, if they've missed the direct appeal timeline. And I talked about that a little bit. It's a lot of times we can't get, they haven't reached us and gotten everything so we could file a notice of appeal, and we can't get it into the appellate court. So in those cases, we would file post-conviction. We go post-conviction. It's an alternative to getting their conviction and sentence reviewed. So we would do that. Sometimes on particularly plea cases, or other tried cases, we need to go back post-conviction to develop the record, because on appeal, everything is based on what's the record in the district court. So if it's, for instance, if someone wants to withdraw their plea because they felt like, that they were really coerced into pleading guilty, or they were made some promises that weren't followed through, or there's something, the plea agreement wasn't followed, or, there's a lot of different reasons why they would challenge their plea. The factual basis may not be there for the crime that they pled guilty to. So we would then go back to district court and make the record on those issues. On tried cases, we see perhaps like newly discovered evidence would be one that we would go back post-conviction. Another one might be ineffective assistance of counsel that we'd go back because those issues have not been dealt with in the district court. So there's no record for us to appeal that until we get a decision by the district court on that. Sometimes juror issues are another one, that something will come up after the trial about the jury, whether it was jury misconduct or something happened during the jury proceedings. So that's when we would do post-conviction in lieu of a direct appeal. So the one thing with the post-conviction, it's all under statute 590. So that's the chapter for post-conviction. The timing is, it has to be filed within 2 years of the conviction or when the appeal is filed. So there's a 2-year limitation there. Again, it seems like that's pretty long, but it goes fast. Especially if they don't contact us till really close to that 2-year mark.
So what's that in session? So initially, so they have 60 days from their conviction to file the appeal.
90 to do a direct appeal.
Yes, for post-conviction it's 60, right?
Yeah, so if we lose at the post-conviction, like say we've done post-conviction instead of the direct appeal, that order on the post-conviction denying relief, we have 60 days to file that notice of appeal to the Court of Appeals or the Supreme Court. So it's a different, like say, just as an example, we would do a post-conviction because they missed the initial direct appeal time. So we file a post-conviction, present all the issues there. We get an order from the district court denying that. Then we can appeal that to the Court of Appeals, and that's a 60-day time period.
Okay. So they can file, so you have 2 years.
2 years to file the post-conviction, and then if we don't succeed there, you can appeal to the Court of Appeals or the Supreme Court.
Okay.
Yeah, it'd be nice if they would give us all the same time period, but they don't. So with the post-conviction proceeding, like I said, it's a 2-year time limit, but there are these exceptions. And so the exceptions that can come up, so if somebody misses the direct appeal time and the 2-year time to file a post-conviction from their conviction, then there's these exceptions. So the first one is a physical or mental disability that precluded the timely assertion. That doesn't come up all that often. We're seeing it a little bit more frequently with a lot of we have a lot more mentally ill defendants that aren't aware of the appeal process, or they're just and actually I had a client several years ago that had dementia, and it was like 6 years after we looked, outside of the 2-year time period, but he just was not able to, we were able to establish his dementia and that he should have the right to review. So that's one of them. The newly discovered evidence, that one will come up, at various times. And that's one of the areas that you'll see, I think, a fair number of post-conviction proceedings that the Innocence Projects that they will take on, because those are things that weren't known at the time of the trial, or without, it says not known with due diligence. So, had the investigator or the defense attorney or the defendant done any due diligence and could have found that evidence, that doesn't fit in there. It has to be new, it has to be newly discovered. And it can be cumulative, and it can't be just for impeachment purposes. So it has to be pretty significant evidence to be able to get through that, past that 2-year time bar. A new interpretation of federal or state constitutional or statutory law. And you also have to show that it's retroactive for this case. We do have a fair number of those. Sometimes, I shouldn't say a fair number. I've seen probably more of those than the other exceptions, because we'll get a decision, say, from either the US Supreme Court or a Minnesota Supreme Court that changes the law. One example is when the Minnesota Supreme Court said that a BB gun was not a firearm. So we had a lot of convictions that were possession of a firearm, and or even use of the firearm during the commission of a crime, and it was actually a BB gun. So we filed a number of post-conviction petitions within that 2-year time that decision came out to get those convictions vacated. And that was, and that one was, well, yeah, and it was retroactive because it was, met the whole criteria for that, which is very complicated. But a lot of them, it's hard to be able to prove that it's retroactive. A real change like that, though, is definitely, and it will also apply to cases that aren't final. So if they were in the process of an appeal and it wasn't final yet, then that will also be applied to those cases. And the last one is that their post-conviction petition is not frivolous and in the interest of justice. And we try to do a number of petitions that way. That's a really hard one, because if you go to the next slide, these petitions, even with the exceptions, they have to be filed within 2 years of when the claim arose. So it's really, if something comes up like the newly discovered evidence, then it's 2 years from that, when that was discovered, to file the post-conviction claim. So when you're talking about, the interest of justice, you may be challenging a plea that wasn't valid, but the claim arose before actually the 2 years. So it arose at the time that the person pled guilty. So that exception is really, really hard to get by on some of those. And we've been working really hard with the legislature to try to get that changed, but so far we haven't been able to.
Can I make just one quick comment?
Yeah.
One thing that I think a lot of people don't realize is that the 2-year time bar is waivable. It is waivable effectively by the county attorneys.
Yeah.
So in some counties, in Hennepin right now, those who are in charge of post-conviction, it's Claire Deagle's unit, will frequently, particularly in innocence cases, their theory is we want to get it right. We don't want to kick out
Yeah.
claims simply for technical reasons. So they will frequently agree to toll the clock.
Yeah.
And we're seeing that, particularly with cases that are also before the conviction integrity unit at Hennepin or the conviction review unit. So one of the issues in Brian Pippett's case, which we all heard, and we had this, really lengthy post-conviction history, why is it if the CRU said he's innocent, can he not then go back and get his conviction overturned in Aitkin County?
Yeah.
Well, in part, it's because Aitkin County is refusing to allow evidence that they claim was over 2 years old, even though it was part of the CRU's efforts to uncover it.
Yeah.
So that's
Yeah.
complicated.
That's exactly right. Carrie, you could have done this.
That one-
No, I only know because I
I was-
continue to
yeah,
lose those.
that's
but
what-
yeah.
That one actually,
I think that was baffling to a lot of us, why he couldn't then go get
Right.
relief in court, why he needed commutation.
well, it was actually a 2-1 vote too, because there was still some outstanding hearing that was supposed to happen at some point in
Yeah.
time.
Which they thought, yeah, I mean, that's the other piece, like we worry about exhaustion of remedies. And technically there was some outstanding hearing, and I think it's Aitkin County, am I getting?
Yeah,
that
it
right?
was.
Yeah, it
Um,
was that, I think the judge said there wouldn't be an evidentiary hearing. And so the defense filed a motion to continue so that they could get some more testing done. Because they couldn't have the testimony.
Yeah,
But that was a question by the board of like, well, you continued this. Why should we be granting relief when the court hasn't determined innocence yet? And ultimately, the board granted relief based on the rehabilitation and the record of Mr. Pippett. So,
Yeah.
and that is something we will talk about because when we're thinking about exhaustion of remedies, I think it is important to talk about how do we see it as the commission? How does the board see it? How does it interact with the court process? Because it is interrelated and there may be times when the commission says the court should handle this first, but
and then the question arises, what county are we in? And
Exactly.
it makes an enormous difference. I mean, because the county attorney has so much discretion. I think Hennepin and Ramsey are usually pretty distinct.
Yeah, yeah, that's what I was gonna point that out, that they can waive the time, they can waive that 2-year time bar. But it is very limited. It's very, and you're right, it's Hennepin and Ramsey and not even in all the cases. And we'll see this, one area that we see a lot of this are then some where the immigration consequences are so significant to the person. And we've got cases that go back decades, where, they have, the person had a conviction. There was no, they either met the criteria for withholding of deportation at the time, or they were granted relief under the Convention Against Torture. And then, more recently, then they've gotten the deportation orders, or for countries that we're not accepting people. And we have, this is the really hard thing about this, where my office does statewide, and we've got Hennepin and Ramsey where they will agree to waive the time period in some cases, not all of them. But then we get outstate with the exact same situation, and they will not waive the 2-year time bar. And even on cases like, so I would guess you're going to see some of those cases come through on the immigration from those cases that are, they've done their time, or they've completed probation. They're, for 20 to 25 years, they've lived in the community and contributed and have no other criminal record. And those are really hard cases when you can't get a prosecutor to look at it and say, yeah, we need to let this post-conviction go through, because, on some of the cases we'll file the post-conviction, not necessarily thinking we're going to win. We want to, and we file what we can, but we can't even get in the door. we can't even get it before the court because the prosecutor won't waive that 2-year time bar, and it's very frustrating.
See a lot of those
I would expect so.
I think from us. That's right.
Yeah.
Yeah.
They-
So this time bar we're talking about is the NAFLA rule, right?
And then the NAFLA
Or-
comes up when somebody has had a direct appeal and they've had counsel, they've had the direct appeal, and then they go back filing a post-conviction after that. And that's where the NAFLA bar comes in, because they say that any issues that could have been raised on appeal or should have been raised on appeal, they're barred from being heard by the district court in a post-conviction. So I put on here the summary dismissal of subsequent post-conviction petitions. It would be in that situation where they've had the direct appeal or they've had a prior post-conviction that was heard on the merits. So the court actually decided the issues and affirmed the conviction. Subsequent PCs, and you've brought this up before, that some people they'll keep filing post convictions, even if they're filing a lot of pro se ones, and they'll keep filing them. They're subject to summary dismissal unless they come up with one of those exceptions and can get through that way. But you have people that are serving really, really long sentences or life, and they keep trying. So they'll keep filing post-conviction petitions. And that's where you'll see multiple ones come through like that. Next slide. I threw this one in here. This is under the Rules of Criminal Procedure 2702. This is one where we can file motions to correct a sentence at any time. So this is not the conviction. This is actually someone's sentence. So we can do these, and it says right in the rule that they can be filed at any time. So if something comes up that it's an illegal sentence, or there's a clerical error, or they just missed something, for instance, the jail credit's wrong, custody credit's wrong, the criminal history score is wrong, that they counted the priors wrong. Sometimes conditional releases shouldn't be put on someone's sentence. Those are kinds of things that we can go back into district court anytime to correct. And they don't go to the conviction, but they do go to the sentence. So, and those are also ones that sometimes we can go back in if there's a change in the law regarding criminal history, or we can, again, it's one of those where we can look at it. Maybe it hasn't come through our office before, but they've heard that there's something maybe wrong with their criminal history. A prior was counted that's no longer, a crime anymore. So we can sometimes go back and get those corrected. A lot of these are really more right when they get into the first few months while they're in prison, when they're saying, I didn't get all my custody credit. Now contact us and we can take care of it that way. But that's another option we can do. Next
I'm
one.
glad you mentioned that, because we have a lot of applications that say my sentence was wrong. And I think that's a good one for us to know, that because there is no time limit, that may be something that is more appropriate to point them to the courts.
Yeah, and I mean, we'll get inquiries also, and I'm guessing you get a lot of these too, where they just feel their sentence is too long. It's too long, and there really isn't anything illegal about it or any basis to challenge it by this means, because we can't go back and just say, okay, he got 86 months. That's really too long for this. He should have, half of that. That's not what we can do. We can't do that. It has to be an illegal sentence. So if it is the actual sentence, or if they got a departure, an upward departure, and the reasons held up on a review, then that's another one that we can't do anything under Rule 27. That would have to be a post-conviction. But again, we're limited on that 2-year time period. So, but I think we get a lot of inquiries like that, their sentence is just too long. And they've talked to, their neighbor in the next cell or out in, somewhere that has the same crime, and they got less time, and so they should get less time too. And that's not taking into account their prior record, their criminal history. So we get a lot of those. And when we get those inquiries, we check into it. But if there isn't anything that we can do a motion to correct, we'll let them know that.
And I'll just mention this for the commissioners. I think for our purposes of review, currently we don't have capacity or enough lawyers in our department to be able to, it takes a deep level of review to tell if the sentence is illegal or a really comprehensive criminal law background. So if we get something saying that we would get an application that says, I think my sentence is wrong, we're going to talk later about this, we should be asking, do we send them back to the courts? Are we supposed to be looking at those to see if they have a valid argument, or is it, you've never made a motion to correct, you should do that, and if they deny it, come back? So those are some of the questions we will consider later.
Criteria allows for that. That's a ground, right?
Yes.
So the statute says that can be a ground for a commutation. That's what's complicated.
Yeah. I mean, if there's a real question about, that maybe they can get it corrected, like I said, we get a lot of inquiries, and you can send them to us. But I think if you look at what they got, the sentencing worksheet, and what if it matches what the sentence is, it's probably not.
Yeah.
Unless there's something on criminal their prior record or something. But when we get those, we go through them and, do a deeper dive into seeing if there is something we can do to reduce their sentence.
Yeah. And that's, again, right after this, or after break, we're going to talk about that intersection and what we are able to do capacity wise and knowledge wise. Because that is something I actually know how to do, to look at criminal history, dive into the sentencing guidelines, all of that.
Yeah.
It's how often should we be doing that?
Okay. The next slide. So another thing that came up in 2023 was the legislature enacted this aiding and abetting felony murder provision, and they actually changed the law on going forward, but also they provided for this retroactive application to first-degree felony murder and second-degree felony murder cases. And so, my office has been very involved with this, and we've reviewed tons and tons of these cases and filed there's a whole process for doing this. It's like completely separate from the post-conviction. It kind of follows the same idea of post-conviction petitions. And there's a preliminary application, and then there's a petition. I think we've screened close to 300 cases since this was enacted. But this is also a limited time period. So everything now for the second-degree felony murders, they all have to be filed by October of this year. The first-degree felony murders were done last October. So a lot of these were ones where the second-degree murder, they had a mistake in the original legislation. So they changed that, which is why they added the extra year on that. So with this, the reason I brought this up is every so often the legislature will do this where, they're looking at something. This was a task force before 2023 that was looking at aiding and abetting cases. Yeah, Perry was on that. She just
wrote this convoluted law.
Yeah. So, but it really makes sense because especially on the first degree felony murder that one's probably the easiest one to understand. If the person was basically there, but didn't cause the death, then the question came up is, are they as culpable and liable as the actual person who caused the death? And there's so many different situations with the aiding and abetting. So the task force made these recommendations. The legislature then enacted this statute and the retroactive application. And we've gotten several people have been resentenced, or the convictions have been vacated, or they've been resentenced to the lesser crime, like the underlying crime, like an ag robbery, or depending on what the felony was, and then somebody died as a result of that. So this is different than premeditated first degree murder. These are the felony murder cases. There's one reason I brought this up is because there may be a few cases that didn't file for relief, maybe they just are not paying attention. They didn't get in, and they're not going to get in before this time period, that may then come with this issue to you. It may be that you'll see some of these down the road a ways that either they, might have been out on parole or, supervised release, or they were done and they didn't get this in, or they didn't qualify for this retroactive piece for various reasons, but they really fit, and they should have gotten the relief. So we've seen a couple, actually a couple of them are right now in litigation, so I won't talk about those, but that happens. So you may see some of those where they're saying, this was an aiding and abetting felony murder case.
The other thing from that I think the statute provides is that there are a lot of people who were charged with first degree aiding and abetting first degree felony murder would not fit now, but the charge forced a plea to second degree murder. So when the bill was heard, a woman named Jamesia Donnerson, who actually was working for Representative Feist at the time, testified. And she had pled out to second degree as a 16-year-old who was sitting in the car outside, when something happened.
Yeah.
Because she was charged with first degree and the plea was forced. And so we had a lot of discussion at the time about what to do with those people.
Yeah.
Particularly if they'd already served their sentence. And I believe there is a provision that says they can come to the Board of Pardons to seek relief.
Yeah.
If that was the case.
Yeah. And we've had some of those cases, but like the ones, again, that either had finished their sentence or had, missed the deadline, didn't know about it, where that exact same thing happened. So we've been trying to, get as many as we can, but it's a matter of if they get the
And
notification.
They're
and
not easy
understand it.
they're not easy to find.
Yeah. So that's something that, I think you will see down the road a ways. There may be a few of those that come through.
The only other thing I'd say about that is we did a study on 10 years of this in Minnesota, see how it intersects with race and ethnicity.
Yeah.
And particularly for Black defendants, 25 times more likely to be charged with some form of aiding and abetting or felony murder or both.
Yeah.
And then in fact, 75% of all murder charges between 2010 and 2020 were either aiding and abetting, felony murder.
Yeah.
So these are common charges.
Yeah.
You can find an underlying felony for really anything.
Yeah, exactly. The next slide. Okay, so then this is another one that it talks with, that's all up to the prosecutor. Same thing in 2023, the legislature passed this law, it's called PISA, the prosecutor initiated sentencing adjustment, and that's in the statute. And so a prosecutor has the discretion to file a petition to adjust or change a defendant's sentence, and they have to have substantial and compelling reasons. Most of the time, it's a lot based on rehabilitation and just they get the input of the victim. But what's really difficult is it's completely discretionary, and so we're seeing this same thing happening where Hennepin and Ramsey have been really, I think, really good about this and in many cases, but you get to the other, 84, 85 counties in the state and they're not doing they, I know one from Wadena County because I know the prosecutor up there who had contacted me about a case, and that's really outstate. That's probably one of the only ones I know of in this, in this time, 3 years. So, the whole thing was really to focus on rehabilitation and to get, input from the victims to see, so they're brought in as well. And like I said, the statute itself, it was aimed to create a more equitable justice system so that they could reconsider some of these really harsh, long sentences with there's new information or change in circumstances, or the defendant has really shown the rehabilitation. But we're not seeing very many of these. And our office is a little bit involved, but they don't really want the, defense attorneys involved in these. It's really like when I get a case where I think, something should be done, I will contact the unit at either CRU or if it's Hennepin County, Ramsey County, I will tell them, here's a case that I think you should look at, but that's like all I can do. I can't, they just really don't want input, or they don't want defense, they don't want attorneys involved. One of the really, so sorry, John.
How was this initiated?
It's initial.
Reach out to them?
Yeah.
Or they just review cases periodically, or?
It kind of depends. It might be brought to their attention by, a family member, or the defendant themselves will contact, or like they'll contact, my office, or maybe Perry, maybe the Innocence Project or CRU, the AG's CRU unit. And they, so they might do that. I know there's, I think in Hennepin, they may have flagged some cases, especially juvenile cases, but it's kind of hit or miss. It's not really, we're not seeing a lot of this happening.
There's an application. So Hennepin put together an application, and they have flagged some cases. The law schools are really involved in representing people. So
Yeah,
each of the law schools has one, but the judges in Hennepin.
Then they have to go to the judge. It can't be just up to the
So
prosecutor.
the prosecutor files, there may be a response from the defendant, but the judges have to agree to grant it. And they are generally not happy with the law. So in every case, Hennepin has now brought 4. And maybe a couple more, but the judges have raised objections to the very essence of the law. I think there are separation of powers concerns, which we don't agree with, obviously, but they also think that it's not adversarial, and it should be. That in fact, the prosecutor is sort of representing the defendant in these cases by bringing it, which is just, we disagree with as well. So I think only one has been granted in Hennepin so far, and that's the Nunn case. That's it. And there, I think Ramsey won't do anything with homicide. I think they're only doing drug cases, and then I think there's maybe 1 or 2 from outstate. So
it's very, very limited.
Yeah.
Which on the flip side is interesting, because under the aiding and abetting felony murder, we did have prosecutors challenging that for separation of powers, saying that the legislature couldn't do this and take it away from the prosecutor, change the court and the prosecutor. So anything someone's gonna be like, you can't do this, or they don't like it. But this is in the statute and it's there. It's just really limited. So,
and so even though, I think for our purposes, when we're thinking about exhaustion of remedies,
it's really
people
not
might say you can apply for PSAP, but statistically, I think Hennepin has looked at dozens and dozens of cases.
I agree. Okay, slide. One more back. Oh wait, okay, what happened there? Oh, I didn't get this other slide in there. That's okay. You can go to the next one on talking about pleas, but what I was going to say is I've talked about the Great Northern Innocence Project, and then we kind of been referring to the CRU, the Conviction Review Unit at the Attorney General's office. And, you know, the Innocence Project, they have a real strict criteria. So like in our cases, if we've done a direct appeal of a client, and then they're claiming innocence, we will refer them to the Innocence Project. Or if we have lost the appeal and there's some issues that are really, you know, really important, but we didn't get anywhere on appeal, we can refer those over to the Innocence Project. So that's one option. Again, they're all subject to the same post-conviction rules that I just went through and the exceptions and everything. And Carly wanted me to talk about this a little bit with you about guilty pleas versus Alford pleas, Goulet pleas, Norgard pleas. All of these are guilty pleas. They're all considered valid guilty pleas. I kind of went through like a standard guilty plea is where the defendant admits all of the facts to support the elements of the offense. So in the plea colloquy, they're asked those specific facts to make sure that they are pleading to that offense. An Alford plea or a Goulet plea is where they'll plead guilty to an offense, but they're still maintaining their innocence. Those are difficult pleas, as are the Norgard pleas, but the one extra step is that the defendant also has to admit on the record and that they reasonably believe that the record establishes that the state has sufficient evidence to obtain a conviction. That's an Alford or Goulet plea. The Norgard plea is where they plead guilty, where they don't remember what happened. Sometimes it's due to, you know, some type of intoxication under the influence of, you know, alcohol or drugs, kind of blackout situation. Or it could be just a mental illness, you know, a breakdown where they don't remember. But again, then the record has to establish that the evidence against the defendant is sufficient, so that if he went to trial, that he would be convicted of that offense. Those Alford pleas and Norgard pleas, the courts are they accept those with caution. And there's a lot of things, you know, there's some judges who will not take an Alford plea to certain offenses. I know several judges we come across that will not take an Alford plea to any sex offense, for instance. And so they're difficult pleas in the sense that you really have to look to make sure that they're admitting, you know, that they know there's enough evidence. Those are the pleas that we probably see challenged the most because they haven't admitted their guilt. But also remember that this is at the time that they're in that district court process, and a lot of them, you know, they've been offered a plea deal. They want to get out of jail. They want the lesser sentence. They don't want to go to trial. They're, you know, afraid to do that. They're just in a really difficult place. And so they'll do these Alford pleas. But, you know, what I also see as time goes on with these cases, you know, if they are on probation, they have to do all of the conditions of their probation to succeed. And so if they have to do some sort of anger management treatment or the sex offender treatment, same thing if they go to prison and they do that, you know, at that point, they've probably, just because they did an Alford plea, they've taken responsibility and they're doing what they need to do to be rehabilitated. Where I think it gets difficult to come, you know, is where they refuse to do all those things. Those are the more difficult ones, because again, you know, they're treated the same as guilty pleas. So going back to challenge those on a post-conviction is very hard to do unless the factual basis is bad, whether there's not an adequate waiver, whether they didn't ask the client the right things. So, you know, and there's times where we can get those withdrawn, but they're difficult for everybody. And so I would guess you will see some of those come through. And I think the most important thing is just to remember that this happened at the time that they pled guilty, and they had a whole lot of pressures. They had a lot going on at the time. And it's kind of what did they do after that? Did they do their programming? Have they been rehabilitated? And so that doesn't seem to mean as much if they've done all those things, as in my opinion anyway. I don't know if you guys have any questions about those.
I have one quick, I was just
Mhm.
curious, do you ever see issues that arise down the line, like whether it's, I guess, I don't know if this would be something you see a lot, but in regards to like an Alfred plea, for instance, if they do all the programming and do everything that was required, like you said, you could argue there's like the rehabilitation and they did everything that was asked, but do you see issues arising from like the point of remorse or accountability? Because I think that's something that we see, and that you can't, or I think it's a struggle to ask someone to show a certain level of remorse or take accountability to which you see fit, if they took an Alfred plea.
It may happen. I would think if they've done the programming, part of the programming is that they have to, they have to acknowledge what happened. And I don't know. I mean, I counsel a lot of clients, where if they're talking about going to treatment, and it's like, you have to, you look at it from the side, look at it from there's the victim side, and how did it affect them? Even if, like, say they believe that on a sex offense, it was consensual, right? But they were convicted. And, it's from the side of the victim, what they went through, how they felt. I mean, I think that's a lot of the programming, that they try to have them look at it from a different viewpoint. And so I think in that sense, they maybe will learn remorse, or they'll be able to understand it better. But, every person is different. I'll say, but I do counsel a lot of them that, you need to do these programs. This is what is required, especially if they're on, probation, or they want to get through the program in prison, or on conditional supervised release. So I think those are, like I said, they're hard.
Mhm.
They're very hard. And then let's see, I just got a couple more slides and then I'll be done. So just, one of the things I just want to point out to you that the reality on appeal and post-conviction, once someone's been convicted, it's difficult to get those cases reversed. The law really does work against us on appeal, because obviously any issues, especially sufficiency, it's, they defer to the fact finder, they defer to the jury's verdict, what the jury found. A lot of issues are waived if it should be, many issues are waived if they're not initially brought up in district court. That's an error on my part. So a lot, some issues that will come up, maybe there should have been a suppression motion filed and there wasn't. Maybe it was a bad stop, a bad search. It wasn't. That's waived if it's not brought up in district court. So there's several issues that sometimes we can work through that on a post-conviction, but sometimes we just can't do it. And also, the one thing to remember is post-conviction petitions are filed back to the same judge who sentenced the person. They either took their plea and they sentenced them, or they sat through the trial and they sentenced that defendant. So the likelihood that, we're going to succeed on that is probably even less than on appeal. And the timeliness issue always works against a defendant. So even if, we can get in under one of the exceptions, the more time that goes by, the more difficult it is to get post-conviction relief. So that's just something to keep in mind, that it really does work against the defendant. And the prosecutor is going to mostly come in and say, I can't retry this case. All my witnesses, they're gone. I don't know where they are. The evidence has been destroyed. And so that carries a lot of weight with a judge in making those decisions. I think that's it. Thank you. You guys have any other questions?
No questions. Thank you, Kathy, so much. This is Carl Crawford for,
Hey, Carl.
hey, my
Good to
friend.
see you good to see you online.
Yes, great to see you.
Kath, oh, go ahead,
Go
Carl.
ahead. No, Kathy, go ahead.
This is Kathy Masarick. I'm a retired judge, and I just want to thank you for
is she?
the clarity with which you outline these issues. And this is just for the other members of the commission. This is a huge issue when we have lots of turnover in the judiciary, particularly with sentence corrections. Sentencing is far more complicated than most people realize in terms of what you can and cannot do and how you document it, how you file it, and who gets notice and all of those things. So I think this was a great presentation, and if I still had some authority in the courts, I would say, could you please come to the annual conference and re-educate everybody? So thank you so much.
You're welcome.
And if I can ask one last question, do you have any, putting you on the spot, so if you don't want to answer, that's okay. Do you have any advice for the commissioners about when they're reviewing these commutations, how to look at the post-conviction record? We get a lot of cases with commutations specifically. Sometimes it's difficult to tell when there is an actual legal issue or not. And some people who have gone through the entire process still think that they have issues. And so I don't know, is there any, having seen how this process worked, is there any advice you would give the commissioners and just how to think about these things?
Yeah, I know, having done commutations and looking at it, I mean, the legal issues at the point where they're asking for commutation are probably the lowest. I mean, I think it's what they've done for rehabilitating and I know some of them can't let go of certain issues, but I mean, that's one of the things that I advise them to. It's like, you know what, this has been decided, you know, and now this is what we have to focus on in your rehabilitation. Sometimes there are issues that are they're really egregious, but we cannot get any relief on those. And usually, I mean, I think sometimes those will probably jump out. You know, like for instance, these, you know, Perry's situation where you have an aiding and abetting felony murder, but they plead down to a second degree murder, really because they don't want a life sentence, and they're, you know, looking at then their part, which maybe isn't an issue, but it is in the sense of what was their culpability in that actual offense, and what have they done since, you know, to rehabilitate and their remorse and all that. So I think that's where I would say the issues kind of are all, you know, looking at the whole picture. Legal issues are hard unless, like I said, you get a case that's outside of, you know, the post-conviction and the direct appeal has all been done. It's over. But you have a change in the law, like say, you know, like the BB gun case or some change in the law where we can't get back in because we couldn't prove it was retroactive, but it really is their case. So maybe in that sense, those would be the kind of legal issues that I think you would want to maybe consider, because it does go again to, did they really, you know, did they commit this crime? What was their culpability when the courts have now changed the law? So that might, you know, that I guess that would kind of be what I'd see. You know, you guys, I'm sure, get all kinds. The subsequent pro se petition, post-conviction petitions, to me, those are people that are just keep trying, and they have really long sentences or life. And so they keep trying and trying to get back into court. And I don't think for, you know, your purposes, they really mean all that, you know. I mean, it's just they're trying what they can to get their conviction or sentence reduced. And you kind of give them credit, it keeps them busy too.
It does.
Mhm.
Some of them do an awful lot of legal research, which, can be quite impressive too.
Well, internal law firm and
Oh, yeah. Oh, yes.
Commissioner
Definitely.
Crawford, do you have a question? Is your hand still up from?
Yeah,
last
more
time?
of a comment. I think for me, moving forward as a non-legal person, what you had, that slide on the different pleas, was so helpful. Because we have seen in some of our reading when someone has an Alfred plea or some of those things, those definitions are key. So just thinking about us, and as we prepare maybe for the next group that may come on and do this work, I think that'll be helpful to have that slide for sure that explains the difference between the three,
Okay.
especially when reading through some of the applications.
Yeah. One question is, when we're in a hearing and it's clear that there are questions, like I think, I'm so glad Judge Mesrick's here. I didn't know you were there, Kathy. I mean, how appropriate do people feel like it is for us to take a moment and turn to Kathy? I mean, I don't know how you feel about it, Kathy. But, well, because we are making a decision on the spot, and I do feel like we often have questions.
Mhm.
I mean, and that's not her role, right? But we sometimes do offer pieces. I don't know if Kathy has any thoughts, but
I have some thoughts.
Yeah, please.
So one, I think if these questions come up before the hearing as part of your review, it's appropriate to reach out to me,
Okay.
and I can try and find answers both before the hearing and mention them during the hearing. Because if you're wondering, someone else might be.
Yeah.
And I also think it's appropriate to bring up those questions during the hearing. Some I might be able to answer, some Perry, you might be able to answer, Judge Mesrick, you might be able to, Nadine. And others. I mean, I think that's part of the great thing about this commission is there's such a breadth of experience that we can use our collective knowledge to get a better context when considering these cases.
yeah, I'm just thinking out loud about whether that's ever seen as, I mean, we want to be as objective as possible when we
Right.
provide that information. I think as a former judge, Kathy probably sits in a somewhat different place than perhaps I do. Just because I represent people, on one side of the view or the other, right? And Carly, I think, sits in a different place as well. I think you're objective in your role as executive director, or at least not currently representing clients. But that's the open question I have for people, is whether everyone's comfortable with us seeking that expertise as part of our deliberations, and whether then we should be cognizant of making room for that. And I think that's part of when we open it up to questions.
Yeah, I think we do this somewhat.
But
Pretty
not in like a
regularly.
formal sort of, it just happens ad hoc, right?
Yeah. And I think under our structure, that's probably the best way to do it.
Yeah. That's probably right.
And it's so dependent on whether or not the applicant is represented by legal counsel or legal counsel who really understands the complexities of the underlying postural procedure too. So it's in a perfect world, it would just be great to have a someone sitting in the back of the room to be our
Exactly.
legal advisor. But I guess, we've got John can opine on law enforcement issues. I mean, there's so many factors that come into play here when we're making our decision, and getting more information is always helpful.
Yes, and this is something I'm thinking about as I think long-term about the commission, like were we to get more resources, what types of positions would be created?
Mhm.
I'm also, as you're talking about the different legal issues, in my mind, I'm thinking, okay, how can we partner with law schools or have
Yeah.
interns to look deeply into the legal issues,
Mhm.
which doesn't require access to our confidential data? Because one of the issues with certain partnerships or volunteering is that like BCA reports and things like that, we cannot get access for that particular information. But with appeals and the appellate record, all of that is public. So that could be a way to leverage some of those resources. And like I said, I am very excited to be starting an internship program, both to help with summary writing and research projects. And I hope that it will continue beyond this summer, so that we can have part-time interns during the school year as well.
Yeah.
Thank you so much.
Thank you.
Thank you.
Thank you, Kathy.
I'll fix what I. Okay, so I could.
I think we're gonna do 10 minutes.
Yeah, we'll take recess for 10 minutes and we'll see everybody back at, we'll call it 11:10, so we'll go for 12 minutes. We're
Carl, do you have a question?
I do. My apologies. I have a hard stop at 11:30.
Okay.
I know we're running just a touch late, so I will have to leave by 11:30.
Okay, if we need to go over any of the training materials individually, I am happy to do that at a later
Excellent.
time.
Thank you. I got to pick up a van at 11:30.
Okay.
And Carly, this is Judge Mesrick. I have the same time constraint. I have to go pick up an aunt at
Oh.
11:30. Well, it's be 9:30 here.
Yours
guess
is
I have
much
a-
more important than mine.
So I have a question. I think I'll have Zach call the meeting back to order.
Okay.
Welcome back, everybody. It's now 11:10 and we'll begin the last stretch of our day. Looks like we have 2 additional agenda items. Discretion of denying computations without a hearing, and then we're going to get some information about traumatic brain injuries. So turn it back over to the executive director.
Thank you, Mr. Chair. Okay, given the information we got just before the meeting started, there are 2 people who are unable to be here after 11:30, and we do have another speaker coming in at 11:30. So the discussion related to denial without a hearing also includes some practice exercises. So I don't know if we can get that done in 20 minutes. We were planning on reviewing cases in July, which is why we were having the training now. So we have a couple of options. We can either do like a lunch meeting completely virtually in the next 2 weeks, where I go over just that information. And so then we will just wait until our 11:30 speaker jumps on, or I can do the beginning of the presentation before the 11 speaker, and then we can continue some work afterwards. My
Quorum matter?
We would still have a quorum. There's still 5 of us if Carl and Judge Messer drop off because Artika,
Oh, right, yep.
Nadine,
Yep.
and you and I, we're barely there. We lose anybody else, we lose quorum.
Okay.
Can you remind me, are we scheduled to go till noon or 12:30? I apologize, I don't
We're
see that.
scheduled to go until 12:30.
Okay.
Oh,
Which is why I'm sensing that there's probably going to be scheduling issues since we're running behind.
Yeah, I thought we were scheduled.
Yeah, I have, it's field day today. I have to leave at noon. to Field day.
Okay.
oh, shoot.
I hate to ask for more of your time because I know you all give a lot of your time, but what do you think a lunch meeting, again, all online, sometime in the next couple of weeks, just so I can give you that information before we provide the summaries for July?
Yeah, let's
That
do
would
that.
work fine for me.
Yes.
Okay,
That works for me.
It works for
thanks.
me as well.
I appreciate that. We do have a 15 minutes until our next speaker. So some of the issues that we will talk about came up during Kathy Middlebrook's presentation. So with this discretion to deny without a hearing, there are only 3 reasons why, or 3 reasons why the commission can choose to do that. One of them is if there is an active challenge in court, if we feel that the applicant has not exhausted remedies, and that's one that we have some very complicated cases to go through. But the other one is the supervised release board. So the commission can choose to deny a commutation without a hearing if they believe it is better suited for first review by the supervised release board. So I'm just previewing some of the things I will be discussing, but with the supervised release board, that one is a really interesting issue because of the way the Board of Pardons has chosen to resolve commutation cases. So for a lot of the cases that have been granted in the first 2 years of this new process have been life sentences. But the motions made on those life sentences are to have the supervised release board review the case at the earliest that they can. And then the decision of whether to release is then within the discretion of the supervised release board. So effectively, the board can say, you can see the supervised release board early, but they still get to decide whether you're released or not. So then for me, that brings up a question of what is our role and how do we relate to the supervised release board? Because we've talked a little bit about in the screening committee about how we don't want to schedule someone who's just about to go to the supervised release board or someone who's just recently been denied by the supervised release board. But then we have a case where like last year they were denied and it was continued 3 years. So do we hear them in the interim? Do we wait the 3 years? Then if they continue it another 3 years, what do we do? So we're going to look at some specific facts and specific cases to kind of talk about that. Because the other thing we know is that there is some deference to the parole board who is specifically appointed to make those release decisions. So how does that interact with the commutation process?
Well, and then there's the other piece of this too, is that this board's position on some of those issues could be different from the next board's position on some of these issues. So it's really hard to what's the word I'm looking for? It's really hard to align with what we want to do because we don't know what the positions are going to be. And those are going to change in 6 months or could change in 6 months.
Yes. And I don't necessarily think the commission should completely align with what the board wants because it's a different perspective. However, I know that
Which board you mean?
the Board of
Pardons.
Pardons.
Okay, yeah.
But I know that that is a consideration because you also don't want to set people up for failure if you know
Right.
this is going to be denied. But that's one reason why I wanted to, like, we talked about doing this process in July. First of all, because we have a very long backlog of commutations, and there may be some cases who are bringing up procedural issues on a 5-year sentence that have never filed a post-conviction motion. So should we be hearing that case, or is that one where we might say you need to exhaust some remedies first? So it's first to see if there are any cases like that where we can give some resolution to the applicant. But also, I think we can think ahead about how do we think this process should be with the next commission and board. So if we set up some policies now, I do think a lot of them will carry over.
I do think having, like, in the event that somebody hasn't done any post-conviction relief, like, it is helpful to see that they've actually tried to do some of that stuff. But then it also could just be, they may not have tried it because they don't know that they can. There's so many different things to think about with that.
One of the issues.
And then there's the cost of doing it.
Yes, that's right. That's right. There are people that are barely above indigency who don't qualify
Right.
for public defenders, and without counsel, it's nearly impossible.
Yeah, you're not going to get any post-conviction relief without a counsel.
Yeah, so again, that was a preview of what we'll talk about.
Yeah.
Perry, did you have?
I mean, the only thing I would say also is that, the supervised release board has a different set of criteria, different statute under which they operate, different appointment structure. They are split by partisan appointment. I mean, there are 5 members for adult cases, 2 the commissioner chairs, 2 from each party are appointed. So majority minority in the House, majority minority in the Senate, and then 2 neurodevelopmental experts for juvenile cases. So they are they're often aligned, but they are they're appointed in a different way. They're operating under different criteria. And one thing that I would also suggest is that they represent different constituencies and communities. It is, unlike our commission, it is not a diverse board. And everyone can draw their own conclusions from how significant that is, but it's not representative of the population that comes before it, which I personally think is really significant. And I think several of the members of the Supervised Release Board think so too. So, you know, we are not identical. And I think, you know, our query may be about forms of redemption and forgiveness and other criteria that is not technical in the way that some of the Supervised Release Board decisions might be. So I don't think we have to defer.
I think in some cases it would be better if we could just make the decision rather than deferring it.
Yeah, but I think that's like, those are the questions we should have with some facts, because there's also
Context. Yeah.
different kinds of cases. For example, someone who has a life sentence and a consecutive sentence afterwards. There's someone with a life sentence, consecutive sentence before. There are also individuals who maybe at 22 years. And so should we be waiting till they have the 27-year review or not? And there's a lot of different factors that go into those questions, and they're different for every case. So, oh yeah, you can look at those brief summaries that are a part of the training materials before the training. Those are similar to what the summaries would look like in July, except without the attachments. But basically, we're going to ask some questions about what questions would you have about these cases? What additional information would you need? What should staff's role be in identifying cases? Because right now we are just presenting pretty much everyone who may be considered, except those that have very clearly exhausted all remedies. So yeah, this is all, again, in preparation. I have a whole presentation, which I can also put in the folder so people can look at it before we schedule this.
I think that would be helpful, Carly.
Yes, I will do that.
Just add another factor on that is it seems pretty rare that somebody is only applying for procedural reasons. There's usually a rehabilitation or
That's right.
other factors that go along with that. And so even if they perhaps had not exhausted all of their remedies for the procedural issues, would this group still consider them under rehabilitation, that sort of thing? So I think it's complex.
That's kind of par for the course, so.
I mean, I'll just add one thing since we have a second, right?
Yep.
And the Supervised Release Board also has to operate within the sentencing structure that exists. So they're not undoing conditions. They're not, if they've got someone with a life sentence, that person, they're not able, I mean, I guess technically the commissioner could release someone early for, you know, some extraordinary reason, but they can't shorten a life sentence. It's a life sentence. They can choose to release or not. And part of our role is to determine whether, you know, if someone has served 22 years of a life sentence and has demonstrated significant rehabilitation, we see some disparity. So say someone was the aider and abetter sitting outside in the car, was young, did not play a significant role. We see different criteria there, or has an emergent medical condition that wasn't quite compassionate release, but can't be treated well in prison. We can look at other factors that they can't. And so that's, you know, I do feel like when the board defers to the Supervised Release Board, it may be in a certain subset of cases where it's truly based on assessments of rehabilitation and not anything else. But part of what we have the ability to do as a commission is serve as sort of a corrective factor on sentences that are inherently too long and not serving public safety because they're not serving any of the justifications for punishment. So they're no longer needed to deter. There's been, if we, I think that's for us to decide.
Thinking about it too, like if we did adopt some form of policy, that would be easy to send that to the board to let them know what our position is and which lane we're choosing to look at some of these through, and maybe that could potentially, change.
Pardon board or supervised release board.
The
Yeah.
pardon board, maybe that could change some of their decisioning to offload some of that to the supervised release board.
That's a great idea. I think that would tee up the issue too.
It would tee it up, which what they do with it is, but then you also have to put into consideration too, that if we do this now, we will be able to get it in front of this board and the next board, which will be
Right.
likely they're not going to be set in their ways because two of them will have never done it. Or three of them potentially.
Justice Gaeta says, I think familiarity with all of this and some significant.
Yeah, and I mean, this will also give staff a little more direction. Because we're not presenting these cases to try and say, okay, let's get rid of a whole bunch, but also we have this discretion. Are there ways that we should use it? And if if we talk about it and do the training and look at the summaries and the cases aren't appropriate for it, then we just say, no, they will stay on the hearing calendar.
But you've identified some very important things. We can't have a 9-year waiting period.
Yeah.
We have to find some ways to be more efficient and work within the resources that we do have. And this is one of those things that we can do.
Well, and what I'll also mention is the commutation waiting period is different than the pardon waiting period. So that forecasting I did was based on our total numbers because we only have 1 year of data. So it's really not a very accurate forecast because we don't know how things change over time.
Right.
But with commutation, because we saw at the beginning that if you schedule by date received, you might get someone who's going to be released in a month, or you might have someone who's only spent 5 years on a first-degree murder. So we prioritize them, and I like our prioritization criteria. We start with objective factors, and then we consider other things. But it is frustrating for some of the individuals that are in prison, especially because we can't tell them how long it'll be. We can say we use all these factors to prioritize, and most of them are like, well, I hit all those factors. And it's like, you might. And also, there are 20 cases in front of you, and we can only hear so many. So,
8 years worth of commutations right now.
yeah.
Thank you all. My apologies, Chair and everyone else, for reading the calendar wrong.
No problem.
I look forward to our lunch meeting.
Thanks, Carl.
And I'm going to drop
Have
off
a great
as
weekend.
well.
Thank you. You too. And if the next presenter has her slides, I'm really interested in the TBI and understanding that as well. So thank you
Yes,
all.
that would be great if the slides could go into our shared file.
Yes.
Yes,
Okay.
and I'll do the
Thank
All
you.
right,
ones for
thank you,
next month.
Carly. This is Judge
Sure.
Mesrick signing off too.
Have a great weekend, Judge Mesrick.
Thank you. Bye-bye.
All right. You do have slides, right?
I do.
Yeah. We might take just a couple minutes to get the computer connected. Uh, just call the meeting back to order.
Our meeting's back in session now, and we're joined by Alec Wendelby on brain injury, traumatic brain injuries, and I believe you're from the Brain Injury Alliance. Welcome, and looking forward to hearing what you have to say today.
Thanks for having me, everyone. Yeah, my name's Alec, and I work with the Minnesota Brain Injury Alliance and Minnesota Stroke Association. Oh, yes. That would sound good. Awesome. So yes, I'm Alec, and I work with the Brain Injury Alliance and Stroke Association. So a lot of what I do is traveling around Minnesota, both in person and virtually, to teach folks a little bit more about the brain injury, stroke, and everything in between. So that's really what we're diving into today. Let's see. So I like to keep things really cool and casual. If you guys have any questions that come up as we're chatting through things, feel free to stop me. Happy to chat through those as we go. And to kick us off, I like to introduce where I'm coming from. So I work with both the Minnesota Brain Injury Alliance and Minnesota Stroke Association. You can think of us as two organizations served by the same group of staff, and we provide free services to anybody in the state impacted by brain injury or stroke, which is awesome. And what brings me to this work is I have 4 uncles. And throughout my time growing up, 2 of my uncles experienced brain injuries and 2 of my uncles experienced strokes, of course, bringing the work very close to your heart. I then got my degree just down the street at Hamlin University in neuroscience, and I've been working with the Brain Injury Alliance ever since. And our mission is all about how do we raise awareness? How do we enhance that quality of life for all people impacted by brain injury or stroke, respectively, dealing with its sudden or perhaps its more long-term consequences. So to give you guys a little agenda of what we'll be talking through today, we're going to kick it off with a really quick program overview and what we do and how we could be of support in your work. We'll then cruise into definitions. Really, what are we talking about when we say brain injury, and some statistic elements. We'll then really loop this in with how this all engages with the correction system and what kind of functional changes we see among survivors who've experienced 1 or more injuries. And then we'll end with some action steps and a good conversation about behaviors versus symptoms. So to kick us off, I like to quickly go through what we do and how we could be of support. So I'll go into the most detail into those first 3 services you see: resource facilitation, education and outreach, and public policy. Outside of those big 3, we also have our case management team, folks who oversee those home and community-based services provided to someone through their waiver program or medical assistance program, and we have volunteers. Now, I like to say our volunteers help us twofold. Firstly, we invite volunteers to come and work with us, really with the goal of regaining skills related to employment. You know, let's say it's been a year since they had their stroke. They want to get back to work. We invite them to work with us so we can send them out with a stellar recommendation when they're ready to go elsewhere. In addition, I have a collection of volunteers that travel with me around Minnesota. That way, when I'm presenting, they can share a little bit more of what does it mean to be a brain injury survivor. So I always like to say, if you or someone you love or someone in your life has an amazing journey with brain injury or stroke, please don't hesitate to send them my way. And then the big program I like to highlight, and you guys will see some little brochures with this information, is resource facilitation. Now, this program started out in 2003, and it's an entirely grant-funded program, free to anyone in the state of Minnesota. And what we're really there to do is help survivors navigate the most challenging aspects of recovery. You know, for some folks, this is how do I find a support group? How do I get back to life as it was before? For others, it's how do I find a doc who understands what I'm going through and get some support in my area of the state. My personal favorite part of this program is it is not metro specific. We divvy up the state based on the different geographical regions. That way we have staff members who oversee each of those regions and know what kind of applicable resources there might be. And finally, this is not limited to the survivor. This is open to caregivers, open to professionals supporting them, and anyone in between. And this can be a 10-day-old injury or a 10-year-old injury. It doesn't matter to us. So nice and accessible. Please don't hesitate to give us a shout if a service like this could be beneficial. I always like to say, hopefully the people you love will never need us. Then just really quickly, I like to highlight myself in our education department and give you guys a little bit of a sense of the various events we do. So ranging from things like our Brain Injury Support Conference, a free conference we do twice a year for survivors and families, a number of events throughout March for Brain Injury Awareness Month and May for Stroke Awareness Month, Our Walk for Thought and Strides for Stroke fundraising events, Mind Matters and Stroke Matters magazines, our professional conferences, and my personal favorite on this list are unmasking brain injury events, kind of an art therapy event to get survivors talking more about their injury. So plenty of opportunities on this end. And then finally, policy. Now, the way we want to go about policy is we do not feel it's appropriate for us to say, this is what's important to brain injury survivors. Instead, we want to bring them together and let them speak for themselves. So what we do is offer 4 to 6 weeks of classes to help that survivor learn, how do I share my story? How do I do so when I'm under time restraints? How do I do so when I'm speaking with a legislator and I might be stressed? And then we bring them to the Capitol to let them speak with those legislators and share their story. And some of the big initiatives we're focusing on right now would be, of course, the protection of medical assistance, goals to increase the income and asset limitations that tend to impoverish folks entering the system, more affordable housing options. And I'm focusing a lot of my time lately on the e-bikes and the e-scooters you see around the metro, trying to do a little brain injury prevention on that end. But if you or someone you love feels strongly about the policy, please don't hesitate to head our way. We'd love to bring you to the Capitol. So that gives you guys a better sense of what we do and how we could be of support, and really segues us into what are we talking about when we say brain injury. Now, ultimately, whenever we say brain injury, I'm really always referring to ABI, acquired brain injury. So this is any injury to the brain we were not born with. It did not happen throughout the birthing process, was not passed down genetically, and will not be getting progressively worse over time, or it isn't degenerative in nature. Now, when we look at ABI, it is in fact the second most prevalent disability in the United States, falling second only to depression, and estimated to impact at least 13.5 million Americans. You can then break this down a little further into traumatic and non-traumatic injury types. Now, a traumatic injury, or a TBI, involves a blow to the head, whether that's the head hitting something or something hitting the head. You can think a fall, an assault, a motor vehicle accident, sporting injury, so on and so forth. Whereas on the non-traumatic side, we see those more internally charged events. Maybe something like a stroke, a lack of oxygen, what we'd call a hypoxic or an anoxic brain injury, maybe a complication during surgery, an infectious disease, or exposure to certain toxins or pesticides. Now, one thing that I think is really important when we have this conversation is how do we talk about these injuries? And I say 3 of the most common phrases you'll hear: mild, moderate, severe. When we say mild, folks are typically referring to a concussion. Now, by and large, most of the research seems to show us nowadays that these classifications are overly simplistic, and they don't necessarily reflect the symptoms that that survivor is going to experience. So I always like to say, we want to put more weight into the symptoms that that person is struggling with and less so into what that classification was at the time of impact. And you can see from that chart underneath there what those 3 big criteria are we're looking into to determine that intensity. So how long was the person unconscious? How much of a coma were they in? And how much PTA, or post-traumatic amnesia, did they experience? And we see each of those getting more intense or having a longer duration with a more severe injury type. But as y'all can guess, I mean, these are only really reflective of what happened right after the impact and less so long-term outcomes. Of course, 2 other common phrases you'll hear: closed and penetrating type injuries. A closed injury being any injury that does not break through the walls of the skull. A penetrating injury, typically something like a bullet or a knife entering in and causing damage to the tissue underneath. Now, we can't get too much further into the basics of brain injury without going all the way down to the foundation. I recently talked our COO into getting me this big fancy neuron, so that's been a nice sell. So we're just going to generally talk through how this cell does what it does. Hopefully I'm on camera okay for you guys. Thank you. So what you'll see with this neuron, we have anywhere from 80 to 100 billion of these guys throughout the brain and throughout the nervous system. And everything begins where you see my little purple section saying message in over here by the dendrites, and ends on this far right-hand side, the axon terminal. So everything begins at these dendrites. You can think of those as reaching arms that stretch out into the environment and pull information to the cell body, the core of that cell, so the message can be interpreted. An electrical impulse is sent down this axon, traveling all the way down until we reach the axon terminal. That's really the electricity you hear moving in your brain. And once it reaches those terminals, that's where we have the release of neurotransmitter. You may hear these referred to as serotonin, dopamine, norepinephrine. And these chemicals float from the tail of this cell to the head of the neighboring cell to carry that message across and move it throughout the body. Now, I think when we're talking about this, it's easy to imagine it like a chain. Like I step on a nail that carries the information up to my brain and back down to move my muscle. But as I'm sure you can guess, it's far more convoluted. And we have many cells talking to many other cells all the time, much more like a web than a chain. And interestingly, we need this to move very quickly for us to function well. So we have this fatty substance, this myelin, that wraps around the cell an awful lot like putting rubber around a copper wire to keep things insulated and moving more quickly. And we'll jump back to that in just a second. But when we look at injuries on the cellular level, what we most commonly see is a DAI, diffuse axonal injury, widespread injury specifically impacting those axonal portions. I like to imagine these like if you had telephone cords getting bound up in a violent windstorm and shearing apart. And unfortunately, unlike the other regions of our body, if one of these cells is gone, it's gone. And its neighbors will need to grow to bridge that gap. And if one of these cells is damaged and unable to send its message, it will almost always be consumed. So the resources it's built of can be used elsewhere in the body. This last one is a little bit more accurate example of a brain. So this is a sheep brain. So what I did here is I cut this sheep brain into 4 segments and used a specific type of dye on this brain. I think this one on the bottom right shows it the best, right above where it says dorsal there. And you'll see it looks an awful lot like what you see in my model here, with gray on the outside and white on the inside. Now what's happening, to keep it basic, my dye can't get through the walls of this fat in the cell. It cannot get through that myelin. It can get in at the head and in at the tail, but not along the axon. Now, what this shows us is the computational regions of the brain. Anywhere that caught that blue, that's where the cells are exchanging information, and that's really where you and I are processing the info. And those interior sections of the brain are more like highways to send those thoughts around and into the body and around the brain. But you can imagine, if someone was, say, to have an impact on that outer portion of the head, the thinking brain, how serious that could be in terms of outcomes among those survivors. And as we talk about the mechanism of injury, I like to compare this one to an egg in the shell. So think about an egg, your brain being an awful lot like that yolk, the shell being like your skull. Now, if I lightly shake that egg, the white is going to keep the yolk suspended so it's not rocking around. But if I more violently shake that egg, I can cause the yolk to rock past the white, hitting those inside walls of the shell and scrambling without cracking it. And that's very similar to what we're talking about here. So let's say I was hit on the front of the head, had an injury in the front of my brain, that would likely show my head was rocking forward, front of my brain hits the front wall of my skull, or a coup injury if it's on the same side of impact. On the flip side, maybe I'm hitting the front of the head and have an injury in the back of my brain. That would likely show that impact, rocked my head backwards, back of my brain hits the back wall of my skull, or a contra coup injury. And in some cases, we can see the brain rocked both directions, causing a coup contra coup type injury. And this brings us into the statistics. So one of the ones I think is really important to start us off with is broadly discussing individuals who are incarcerated experiencing brain injury. And when we look across the US at national prison studies, we see about 60% of those incarcerated are living with a traumatic brain injury. Now, when we compare this to the general population, it's anywhere from 8 to 15%, depending on where we look. So, I mean, you guys can guess. On the low end of that scale, it's nearly 5 times higher. On the high end of that scale, it's even more serious. Yes.
Oh, maybe it's going to come up next. I was going to ask if it's people coming into the prison system who have TBIs, or if there's an event that happens while they're incarcerated.
Great question. And we typically see these studies looking at those coming into the prisons with TBI. But of course, then you can imagine with everything going on in the correction system, how likely it is for them to get a secondary injury as a result. Great question. When we look a little further, again, about 60% of adults in correctional facilities have that history of TBI, but we also see around 1/3 of juveniles have that history of TBI as well. And one factor that I think is really important is childhood TBI seems to be very predictive of some of those future behaviors, including offending behaviors, arrest and conviction, and petty crime. And what I find is all too often, if a kiddo does not have that brain injury properly recognized at the start, then let's say 5 years down the line, they're struggling with some symptoms, and that's not being properly equated to the brain injury, and then we're not really dealing with that head on. In addition, the studies seem to show that individuals with that history of TBI are about 2.5 times more likely to be incarcerated when compared to their peers, even when committing similar crimes. So of course, what kind of factors are reducing that survivor's ability to advocate for themselves or explain the situation going on that led them to this event? And the research, again, seems to show us when we compare those folks with a TBI to peers without that TBI, those with a TBI have a higher lifetime occurrence of arrest. They're more likely to commit person-to-person crime throughout their life. They display higher rates of recidivism, are often less engaged with treatment protocol, and importantly, are likely to display some of those behaviors that provoke the actions of corrections officers or other inmates. The big factor is that these are not intentional. The person is not trying to be a problem, but these behaviors are often misconstrued. And then the person is given a lot of grief, oftentimes compromising that person's ability to properly rehabilitate back into the community. Now, when we look at how did these injuries happen, this first one takes a look at general population mechanism of injury. And you guys can see nearly 50% of these are falls. And this is largely made up by the youngest and oldest in our population below the age of 5 or above the age of 75. And then we get a bit more variable with that second half, motor vehicle accidents being the most significant there. Now, when we flip over to look at mechanisms of injury, specifically in male inmates, and unfortunately, we don't have as much great data for our female inmates quite yet, but for our male inmates, we see assault being the biggest factor. And many times when someone has experienced their injury as the result of assault, we see the PTSD that comes along with that, and oftentimes more serious injuries than what we might see in more of a commonplace fall type injury.
So when we're talking about assault, are we talking about we're getting into fights all the time, or are we talking about child abuse?
Specifically fights in this one, and actually, that's a good question. I don't know how much they delineate between, say, like childhood abuse or, say, like fights as an adult. I don't know if they're really looking to delineate between the two. So I couldn't tell you for sure, but assault's overarchingly. There are also some demographic differences we see among different populations. Specifically, our Native American and Alaskan Native patients display the highest rates of TBI-related hospitalization and death across the board. And we see our non-Hispanic Black and Hispanic patients having a lower likelihood of being discharged to a care facility and therefore less likely to receive some of those follow-up rehabilitative services, oftentimes making it more challenging to move forward in their recovery. And yes.
I think there are also studies that talk about how you talked a little bit about the myelin connection.
Yes.
And the process of myelination, which happens, I think, as the brain develops. I mean, you're either, you have an overload of synaptic connections.
Yes.
Right? And it's the pruning mechanism, getting rid of unnecessary and overstimulating connections that happens during adolescence and helps you refine forms of executive functioning, et cetera. I mean, so for, there are going to be folks who had exposure to, say, adverse childhood experiences, or exposed to violence as kids, or lack of pro-social opportunities. So is it fair to say that they will have a myelination process that is less healthy anyway, such that a TBI can be even more problematic?
I would say oftentimes we can make that conclusion. Not necessarily always, but oftentimes.
Often, okay.
Yes.
And then within, so one of the things that people always argue about with detention is that confining kids who are going through the myelination process actually is a form of brain injury in its own right.
Yes.
So I'm thinking it's reading this, that it's just compounded. Is that fair?
Definitely, definitely. And when we see kiddos maybe not using that good myelination process and they're not using those supporting cells, when they get used less often, then it's a lower level of myelination across the board. So of course, making it more challenging. Great question.
No, I just had never made that connection before with the sort of the injury process.
Totally. And when we look a little bit more specifically in Minnesota correctional facilities, Dr. Adam Piccolino is doing some great research on this end. It seems that about 82% of inmates in Minnesota have that likely TBI history. And out of this 82%, a quarter of these inmates will have either 3 separate TBI incidents or 1 incident that would be listed as moderate or higher. And out of these prisoners, they're of course going to be more likely to experience those issues that arise as the result of brain injury, depression, anxiety, substance use disorders, suicidal thoughts, and/or attempts. And one of the last pieces I like to touch on here is very close to my heart. It regards domestic violence and intimate partner violence. The new research indicates that the number of women who have experienced a brain injury secondary to domestic violence is 11 to 12 times greater than all military and all athlete brain injuries combined. And I mean, when we talk about brain injury, who are we thinking about? Our athletes and our veterans. And just to consider that it could be anywhere, even any times higher among this population is incredibly worrisome. So I actually make monthly visits out to the Harriet Tubman shelter in Maplewood to meet with survivors of domestic violence and families, but a lot of work we need to do on this end yet. And that gives you a better sense of who we're talking about when we say brain injury, and really segues us into what are some of those functional changes and symptoms we can see among survivors that make this process more challenging. Now, whether it is due to a lack of representation, a lack of support for that survivor, survivors are oftentimes not going to be receiving the support that they need when they're entering the system. And from my personal experience, I can certainly say this was the case for my uncle, where he was not given a public defender who understood the impact of brain injury. There was no conversation about brain injury in the courtroom, and of course, that was therefore not reflected in his sentencing. And to be frank with you, he lived with those effects for the rest of his life. So how do we really take into consideration that these folks may be in need of additional support and additional representation to understand that brain injury? So I'm sure you guys have seen an image like this one before. This is the different functional regions of the brain. So we're not going to spend too much time here, but we're going to cruise through what these different functional regions are, what kind of properties they give us, and what kind of changes we might see. So as we talk about this, those 4 colored sections you see up top, those would be called your cerebrum. Then we have our cerebellum, often called the little brain or the movement center down on the bottom, connected with the brain stem. And then we have our deep brain structures for our limbic system. So kicking us off with the frontal lobe, being our highest level processing functions, things that let you and I navigate an incredibly complicated world. Things like planning, regulating our emotions and our behavior to be reflective of the situation, making sure we're not flying off the handle. Maintaining our energy. You know, if it's 10 a.m. and we woke up at 8, we want to make sure we're not burned out for the day by 11 and budget our day. Also, executive function controls, letting us decide this is something I should pay attention to or this is something I can forego for now. And we see the prefrontal cortex, this frontmost region of the frontal lobe, is where a lot of new research is coming out. And it seems that this is really the seat of personality and the seat of judgment, giving us a lot of our abilities in terms of personal expression. Now, because of its proximity in the head, the frontal lobe is one of the regions most impacted by brain injury, often leading that survivor to feel different in their personal experience, in their identity, in their ability to make good decisions for themselves.
Good question about
Yes.
that. So we've seen significant uptick in identified autism. My son being one that was diagnosed with ASD, and a lot of these symptoms are the same.
Yes.
And so then I'm having to wonder, like, he was driving his little Power Wheels car at age 2 and decided to drive it down the stairs, crashed. Is that what happened? Or is it legitimately ASD?
Totally. I have this question very, very often. What I always like to say is, at the end of the day, it might not be that important. It might not be that important if it is ASD or if it is TBI, but if we can at least work on symptoms directly, we can see a lot of those issues go away. So maybe don't put too much weight into it, but I think you're totally right. I mean, we see so much overlap between something like brain injury and a variety of different neurological diseases and conditions. So it's kind of muddy there. Great question. Thank you. And one factor I think is really important when talking to folks in the corrections system would, of course, be confabulations or false memories. Now, keep in mind, any of us could confabulate. You or I could confabulate today, but we see it more commonly among survivors. And I like to give you a for instance. So let's say I have a friend come home from work and tell me a story about a crazy customer he dealt with that day. Now, a few years down the line, I'm telling this story to someone else. But when I'm saying it as though it happened to me, not something my friend told me. Now, in that instance, I'm just misremembering. I'm not trying to lie. I'm not trying to be deceitful. And that's basically a confabulation. And this can range from something totally plausible to something completely unrealistic, maybe something they saw on TV or heard on the radio, or like my example, heard from a friend. But the big dividing factor is that this person has no motivation to be deceitful, and they're truly just misremembering. But I'm sure you can guess, when they're trying to report accurately to their PO, to the judge, to the corrections officer, they're often given a lot of grief when perhaps we should not be holding them to the expectation of constantly accurate reporting. And this is one I like to bring up early on with the survivor. I mean, let's be real. None of us like to be told we're wrong. So if we can plant the seed earlier to say, hey, if I'm bringing this to you, it's not because I'm trying to hurt your feelings or tell you you're wrong. It's because I want you to remember this correctly. Not always. It can take some of those hurt feelings away. Some other conditions we see following a frontal injury, one of these being anosognosia. And so anosognosia is any condition that implies the survivor has a lack of awareness. They don't recognize where the deficits are coming from. And you can imagine this makes it quite a bit more challenging to work around those issues. Of course, many survivors are going to struggle with the impulse control, oftentimes leading them to say things recklessly or impulsively or even hurtfully without the awareness of how this could impact others. And one that I saw very often in my case management days was changes in the autonomic consciousness, or our ability to shift our perspective through time, often leaving survivors trapped in a certain period of time. Like for some folks I work with, it would be something like, she got into a really bad argument with her sister last year. We talk about nothing but this at our meetings. Or for other folks, he's got a room inspection in 3 weeks. We are talking about nothing else at our meeting but that room inspection. And of course, how do we focus on what we're doing today if their mind is not there? Another one I think is important is aggression. Now, when we talk about aggression, I do like to say aggression is not ubiquitous across survivors. And only about 28% of survivors are going to report significant aggression, with the bulk of these folks being primarily verbally aggressive. But this can range from that verbal aggression to physical aggression to just being inappropriate and having outbursts. But you can imagine this makes it really challenging for survivors to maintain relationships, especially with people they love, and making it more challenging for them to get those good supporters in their life. And we typically see aggression after primary damage to this orbital frontal region beneath the temporal and above the eyes. And again, often leading to those legal outcomes, those legal issues and vocational issues as a result. Now, when it comes to strategies for aggression specifically, I like to recommend PEST. PEST standing for patience, empathizing, surroundings, and trying not to take it personally. So to kick us off up top, patience. I mean, making sure that our expectations for the survivor are fair and trying to keep our emotions in check as much as possible. And then empathizing, understanding the person may be going through a lot and try to put yourself into their shoes and understand it from their perspective. That does not mean you have to agree with their perspective, but it means you get where they're coming from and keeping in mind that they might be going through a lot more than what you and I can see on the surface. And I think the most important one here is surroundings. Many survivors will experience sensory symptoms like light sensitivity, sound sensitivity, smell sensitivity that can set them on edge. I know in a few folks I worked with, you'd always be able to tell if you were going to have a bad meeting by how warm the room was. And that'd give you a good sense to say, okay, we got to wrap this one up rather quickly. So paying attention, is this person more on edge when they're in a crowded room? If it's warm, if there's a lot of smells around. And then finally, trying not to take it personally. Now, of course, this is easier said than done, but understanding that if this is a physical change to the brain, this is not the person's intention many times. So trying not to take that so much to heart. And maybe one of the most ubiquitous symptoms we see, fatigue. Now, about 70% of survivors are going to report a significant degree of fatigue. And I like to compare this to a jar of change. So think about the average person's brain, a neurotypical brain. Let's say they get good sleep, they got a full jar of that change. Now, throughout their day, maybe they wake up, brush their teeth, they spend a dime, make their breakfast, spend a quarter. But because you've done these things before, it lets you budget and estimate throughout your day. Now, after brain injury, we are doing things differently. And if we're doing things differently, something that might have cost us a dime before is costing us a quarter today, leaving that survivor to think they're budgeting their day accordingly, and they hit a wall. And we see folks lashing out, making those reckless and impulsive decisions because they don't have the energy to keep those emotions down. And when it comes to strategies for fatigue, I like to recommend TIRE. So TIRE, standing for taking breaks, identifying, resuming, and enhancing. So up top, one of the most important, giving our survivors the opportunity to take breaks as needed. If they're running low on steam or we're noticing that they're displaying some warning signs of being overly fatigued, how can we build it into their plan that they're allowed to take breaks as they see fit? And then identifying, how can we work with that survivor to help them self-identify, these are my warning signs of fatigue. That way they're a little bit more ready to deal with those as they arise. And slowly resuming, gradually doing things we did prior to injury, starting with things we got a little bit more familiarity with, and then slowly increasing and enhancing the complexity of those tasks over time, focusing on time management and task prioritization. This then brings us to the temporal lobes. I always like to ask, is anybody in the room left-handed? A couple folks, awesome. So for those of us in the room who are right-handed, we'll see the language center in this left half of the temporal. For those who are left-handed, we'll see the language center in the right half of the temporal. So there is some mirroring of the brain based on hand dominance. And I always get this question for folks who are ambidextrous. It typically starts on one side and then will slowly bleed over to the other. But for temporal, it's largely our language and auditory processing center, producing speech, understanding noises from the environment, and keeping memories and tasks in order chronologically. We then have our parietal lobe at this back crown of the head. And this is primarily the seat for our sense of touch, pain, pressure, temperature, sensitivity, all of those come together. It also gives us bodily awareness, how we can detect where our limbs are in space, and spatial perception, being able to see the room around you and organize that in your head. Now, interestingly, parietal lobe injuries will often result in impairments to scholastic skills, reading comprehension, writing, and mathematics. And I cannot tell you guys how often survivors I work with are treated as though they're stupid because they can't as accurately read or do math or write for themselves. Now, 9 out of 10 times, this person is equally as intelligent. It just takes them a little longer to get from A to B. So if we can be more patient and allow them to work through that on their own, it gets easier as time goes on. And some common changes we see following a temporal or parietal lobe injury, some of these being aphasia. We see aphasia a little bit more commonly among stroke survivors, but we certainly see it in brain injury as well. And this would be a communicative disorder that impacts the fluency, repetition, or understanding of speech. So if it's something like Broca's, the person cannot accurately produce speech, and often their speech is a little slowed or delayed, but they understand what they're saying. Whereas something like Wernicke's aphasia, this is where we cannot understand the speech we're producing, leaving the person to think they're speaking accurately, and it's kind of coming out like mumbo jumbo. And you can imagine how frustrating that would be for the person. Another one I see that's really obscure would be an anomia. And an anomia is trouble naming objects. So a person might be able to recognize what a pencil does, but be unable to give it the name pencil. Of course, many survivors beat themselves up quite a bit over this without understanding it's a physical aspect of the brain injury. And then those parietal changes, things like the inability to find the right words or symbols for writing, issues reading, or issues doing mathematics. This then brings us to the occipital lobe. This is at that back crown, or the very back of the head. And this is the visual center, where you and I detect the color, size, and shape of objects in the environment. I'm sure many of us will relate to the experience, I know I do, of seeing stars or having your bell rung, especially if you're hit a punch to the face oftentimes. moves your head and gives us this experience of seeing stars or having our bell rung. Now, of course, what this is a contra coup brain injury. That impact rocks the head backward, and the visual center hits that back wall of the skull, distorting our vision and giving us that experience of seeing stars. And this is oftentimes one way that survivors will report to me, their brain injury survivors, as many folks may not have the awareness. And then we have the cerebellum. Now, what's unique about the cerebellum, it has direct communication with the spinal column. So unlike these other regions of the brain, it doesn't need to bypass all these other junction points to talk to the body. So it does a lot with our movement-related abilities. Balance, coordination, fine and skilled motor movement, even reflexes. Like, let's say I had a handful of dust and I kind of blow it at you and you blink without thinking about it. That'd be your cerebellum, blinking those eyes to keep you protected from the dust without needing to bypass the rest of your brain for timeliness. And then the final two sections, the brain stem and the limbic system. Now, arguably, the brain stem is the most important region of the brain. This is the primary connection point between all of these other structures and the spinal column. And if we lose this connection, we lose our most basic life-saving functions, automatic heartbeat, automatic breathing. And we'll often see intense coma states as the result of a brainstem injury. And finally, our limbic system. Now, the limbic system is the least cut and dry. It is a collection of deep brain structures. For instance, you can see a couple of those here, like with this green guy as the cingulate gyrus and the basal ganglia being underneath that one. But the limbic system largely gives us our emotional interpretation, how we respond to things emotionally, also arousal, both sexual and motivational, and memory abilities to say this was a good day or this was a bad day and remember it accordingly. Now, what I think is really interesting is we see the limbic system build connections, build bridges with the front of the brain over time. And that's what we often attribute to emotional maturity and the ability to make good decisions. Now, after brain injury, this is one of the first pathways that tends to be cut, often leaving that survivor to maybe be more emotional, more empathetic, act more childlike, or be more prone to emotional liability. And oftentimes, it takes a long, long time for that survivor to work through those issues and figure out where is this coming from. And the final case study I like to talk about here, a really interesting one, patient SM. So you could see these little purple sections in the brain there, roughly the size and shape of an almond. If we talk about one, it's your amygdala. If we talk about both, they are your amygdalae. So patient SM had an incredibly unique condition, bilateral amygdala calcification, which is a mouthful, but both of these amygdala turned to bone in a flash. This was the result of a genetic condition, so don't be worried. We've only seen it in about 5 people worldwide. But because it was only this part of the brain that calcified, turned to bone, it let the researchers see what did she lose. And following that part of the brain calcifying, SM no longer experienced fear or anxiety, period. To this day, she has never been anxious or afraid again about anything. And oftentimes I'll give this example when I'm chatting in the community and folks will say, wouldn't that be awesome? You know, you're not anxious, you're not afraid, you're just living your life. I'll be the first to tell you it was only to her detriment because she lost her most basic safety precautions. She no longer had a little Jiminy Cricket saying, hey, you just got home from work. Do you plan to feed your kids tonight? Or it's freezing outside. Are you going to put on a jacket? And she'd often be put in these really precarious situations because she didn't have the awareness to say, how could this impact me? Now, of course, this is a pretty extreme example, but you can imagine if that pathway even minutely was severed between that decision-making part of the brain and any of these structures, how that could really significantly impact that person's ability to make good decisions for themselves, especially ones that would keep them safe. Now, before we go any further, I think it's critical we say, once you have seen one brain injury, you have seen one brain injury. Oftentimes, I find it can be easy to make overgeneralizations and say, you know, well, this person's dealing with an injury here, they must be dealing with X, Y, and Z. But the rules are not that hard and fast. The brain is built uniquely and injured uniquely. So once you've seen one, even if it's your own, you've seen one. And this brings us to our action steps. Really, how can we take this information, understand it, and implement it in terms of the correction system? So as I'm sure you guys can guess, individuals with that TBI history are more likely to exhibit the difficulties in correctional facilities. They're more likely to have trouble understanding directions. They're more likely to act impulsively or have rapid mood swings. They're more likely to have that increased sensitivity to lights or noises, setting them on edge. And they're more likely to respond aggressively to staff or inmates, struggle with decision-making, and struggle with emotional regulation across the board. The impact that this has is an increased disciplinary action 9 out of 10 times, often leading to a lesser effectiveness in the rehabilitation when in corrections, and therefore a poorer transition back into the community, and therefore a higher likelihood of that person reoffending and going back into the cycle again. And when we look at recidivism specifically, the research suggests that individuals with a TBI history have recidivism rates of about 51%, whereas those without the history of TBI are right around at 33%, so significantly higher within these communities. Another really big factor is substance use. We see the research really demonstrate that there's a strong link between substance use and traumatic brain injury, and it seems to be a two-way street. If the person is using substances, it increases the risk of them experiencing a brain injury for a variety of reasons. And if they've got a brain injury, it's more likely they're going to use things like substances to cope with the changes that arise after brain injury. And pre-existing substance use is incredibly predictive of substance use following the injury. You know, it doesn't just magically go away if somebody has a brain injury, and is oftentimes going to be associated with poor outcomes and poor neurological deficits among those survivors. So when we talk about the action that's already been taken, one piece that I'm always really excited to talk about is Cassie's Law. Cassie's Law being an order to direct judges or anyone leading in criminal sentencing to ensure a neuropsychological evaluation is completed before that person is sentenced. And that's just passed a few years back, so we're still looking to see it get implemented all the way across the state, but this is a great first step. In addition, the Minnesota Department of Corrections did implement a TBI screening process upon intake, so we can really assess, is this person struggling with brain injury? But as next steps, we really want to coordinate with what are the follow-up things we can provide to these survivors to make sure that accommodations are going to be provided to them upon release. How can we establish relationships between folks like us at the Brain Injury Alliance, resources in the community and rehabilitative resources? And how can we stay up to date on trainings, what the new signs, symptoms, and de-escalation strategies might be for survivors? And we know this is a more challenging process than what we would often give it credit for. But some things we can do to really help support these survivors would be routinely evaluating for what kind of symptoms are we seeing, what kind of behaviors are arising, and how can we identify and implement those symptom-specific strategies? And then discuss what kind of services are going to be optimal for the care of that person, and both their physical and their mental health. So up next, this actually comes from a study we did back in 2015. So this is actually the screening tool that we used in the Department of Corrections to assess brain injury incidents. So we won't go too far into the weeds here, but firstly asking if the person has ever been knocked out, if they've been dazed, if they've seen stars, been confused, or had a period of time like that after a hit to the head. And then moving into some questions asking about the cause of that head injury, if the person was knocked out during that impact, how long they were knocked out, if so. And then asking for some more clarity if that person responded negatively to that initial question about brain injury to see, have they had a fractured skull? Have they had something that might be a brain injury to us that they might not think is a brain injury themselves? And from this study, you can see a little bit of our results. So this would be what the person was, what the planning statistics were for individuals when they left the Department of Corrections. So you can see significant amount of referrals for each of these, whether it's Rule 25 assessments, assessments for long-term care or Social Security applications, psychiatric appointments, medical assistance applications, and even referrals to our resource facilitation program at the Brain Injury Alliance. So I think this one gives us a really good sense of services are needed for these folks. And when we make these services accessible, not only do the people take the bait, but they follow up with these services. And there are many folks that we've worked with since they left the Department of Corrections that are now doing tremendously successfully in terms of their recovery. I also think it's very important we say, brain injury 9 out of 10 times is invisible. There are no signs on the surface that the person is struggling. And for this reason, Survivors are often not given the same respect, the same patience, the same credence that a survivor with a more obvious physical disability might be. They might appear to be fine on the outside, but that does not mean they don't have a lot going on under the skull. And this might lead them to become quickly frustrated, often escalating situations and getting them out of hand when we wouldn't expect them to. So just remember, this is a multifaceted injury that impacts every part of how this person lives their life. And it's going to be a little different from person to person. If a situation does begin to escalate, firstly, avoid overreacting yourself and reacting emotionally yourself. We don't want to egg on this person with our emotional response. And if possible, trying to relocate them to a quieter, less stimulating or less overstimulating place, acknowledging their feelings. Again, that does not mean you have to agree with their feelings, but at least acknowledging them. And if possible, or if needed, providing that supportive feedback. And if it's not, then maybe redirecting the person to a different topic, a different activity to get it off the front of their mind. And some general recommendations when working with TBI survivors. There are some ways you can work to minimize the symptoms. One thing I find to be really successful is using super concrete examples. If I give a survivor a super hypothetical situation, they may not be able to conceptualize that as well as I am, and it might make it more confusing for them. So really clearly explain expectations and avoid getting too deep into the hypotheticals. Also asking open-ended questions. If I ask them, did you have a good day? It makes it easy for them to say yes or no and leave it at that. But if I ask, how was your day? They'll say, it was okay, it was fine, it was bad. But that is already a way more thoughtful response from the person. And if possible, have those important conversations in a quieter, less stimulating place and speak slowly and utilize patience. That does not mean you need to dumb it down for the person, but you don't want to be rattling everything off at once and give them enough time to process it. And this brings us to the end of our conversation, behaviors versus symptoms. And I think this is one of the most important pieces.
Can I actually make a comment based on that last slide?
Absolutely.
So something I'm noticing about this is if you read these for our context, doing that in every case probably would have better results for most applicants because it's about asking open-ended questions, being patient, because we're not always going to know if the person has a brain injury, but all of these recommendations also are related to motivational interviewing and good court practices.
Well, and if 80% of people in custody have a brain injury, the likelihood of somebody that's appearing in front of us, they probably have one.
Yes. More often than not, at least. Thank you. Yes, and then behaviors versus symptoms. So when we have this conversation, I like to say, what story are we telling? Are we telling the story about a survivor who has symptoms, or are we saying a survivor who displays troublesome behaviors? And a lot of times it's all about your perspective. So I like to show my fun little optical illusion. Usually when I do, about half the room will tell me they see a bird and the other half of the room will tell me they see a rabbit. And all my clicker will work here. But if you look at that one, you can either see that as the beak of the bird or the ears of the rabbit and the nose on the far side. I show the silly image to say, the image does not change. But if you change the way you look at it, you can see something different. And it is the exact same when we are talking behaviors versus symptoms. So on the left, you'll see how things are commonly categorized as a troublesome behavior. And on the right, how we might be able to reflect those more accurately through symptoms. So I'll hear something like, the inmate is aggressive or easily irritated. Now, the person might be easily irritated, but why? And it's oftentimes going to be that sensory overload, the lights, the sounds, the smells, setting them on edge. Or maybe they're having those emotional regulation issues. Maybe they're overwhelmed, or maybe more simply, they're frustrated by all these new difficulties they weren't expecting to take on. But each of these four are far easier to work on with the person than saying, you have meltdowns and putting all the blame on their shoulders. Similarly, making inappropriate comments. Let's be real, brain injury survivors do make inappropriate comments. But if we can simply keep it in the back of our mind that this is an impaired judgment, it's an impaired reasoning, it can take a lot of those hurt feelings away. I especially see this within spousal relationships. Or we will often hear the person is disobedient, they will not follow instructions. And all too often, those instructions weren't given the right way in the first place. Like if you have a slower processing speed and I'm rattling off commands, I can't expect you to work through those. Or if you have memory difficulties and I've given you a laundry list of things to accomplish, I can't expect you to just spontaneously remember all of them. Or the one I hear probably the most, your survivor has missed their appointment, they've missed their court meeting, they've missed this appointment. And all too often, again, they're being held to unrealistic expectations. If you have memory concerns, maybe we can't expect you to just remember your appointment off the cuff. Or if you have fatigue, if there is no more change in your jar to give, how can we expect you to keep pushing ahead when you have no more steam under the hood? And really what I want to get at across the board here is almost always we can more accurately reflect what's going on with that person by looking at the individual symptoms and taking a step back from the presence of troublesome behaviors. Now, there might be a survivor you work with who is displaying a particularly negative behavior that is not tied to a symptom. What can you do there? I like to begin by looking at, is there a trigger? Is there a predictor? Is there something that lets me know the behavior is going to arise? There may or may not be. But most importantly, what is the message? What unmet goal? What remaining frustration, desire, or expectation is this person expressing to me? And how can I teach them to communicate the same need, the same want, the same frustration without it becoming a barrier to them getting what they want? Of course, easier said than done, but a good way to think about it. And as a nice quote here from Rick. Rick is a survivor who comes with me pretty often when I'm in the community. Recovery does happen. Doctors tell families that the recovery is a 2-year process and the survivor will plateau and it stops. Well, there are things that I can do today that maybe I couldn't do yesterday. The recovery never stops. And let's summarize. So while it's very important, we acknowledge that there is an association between criminal justice and involvement in TBI. This is not the end all be all, nor do I want to give you guys the expectation that all brain injury survivors are going to engage in criminal behavior. This is certainly not the case. But what we can do is better understand that these injuries impact all parts of how this person lives their life. And by practicing patience and understanding the perspective of where these folks are coming from, we can be better supporters for them. And by being flexible, willing to adapt, even if situations are escalating, we can better understand the reasons why this is happening. And I think this is the most important thing I say at these sessions. I meet hundreds, if not thousands, of survivors a year, and I cannot tell you guys how much grief these folks give themselves. They'll say, I used to be the primary breadwinner. I used to take care of my folks. I used to be a good dad. I used to be a member of my community, and they're beating themselves up because they're comparing themselves to a brain they no longer have. And that's not fair. So instead, what are the shoes we stand in today? What are our strengths? How can we highlight those strengths? What are our limitations? How can we reduce limitations and make this new normal as comfortable for the survivor as possible? And again, I hope the people in your life will never have any need for our services, but in case they do, we are located actually just up the road in Roseville. Feel free to pay us a visit, shoot us an email, give us a phone call, whatever works best for you. And I did want to leave just a little bit of time for questions. You guys will also just see a QR on the screen there that lets you complete an evaluation for me. Let me know how I did, which is always appreciated. But any questions we can answer? No pressure. I won't twist any arms.
This is fantastic.
Yeah, this is an extremely good presentation.
Well, and I want to thank you guys for having me. Of course, like I say, this work is very close to my heart. My uncle was heavily involved with the Wisconsin Department of Corrections. And to be frank, it was a major challenge for him to understand, how do we understand brain injury? How do we get out of corrections? And like I say, something he struggled with until he passed. So this work is very close to my heart, and I appreciate you guys having me.
I'd be interested to have you watch a day of hearings and see how many people you think fit the category.
That would be a hoot and a half.
Well, because before I got into this work, I didn't know anything about it.
How would you know?
Right.
Right.
And I still don't know much about it other than learning more about it. But I'd be interested to see how many folks that we interact with where you see it's this person clearly has TBI.
Yes.
Whereas we might be missing it altogether.
Yes, you might not see it. Totally.
The only way we really know is if somebody tells us.
Yes, if they're reporting it.
Right.
And the one thing that I think is a super clear, like really good indicator are those sensory symptoms. Because we can see pretty much everything else being seen in other conditions like ASD or PTSD, but it really seems like those sensory symptoms only arise with the most severity after traumatic type brain injuries. So that's always one of my best kind of ways to snuff out, is this brain injury or is this something else convoluted going on?
One thing that's really, there's this sort of famous case of a guy who basically was an older guy who started to engage with child pornography.
Yes.
Do you know this?
Yes, I know exactly what you're saying. The tumor, right?
Yes.
Yes.
Yeah. So I mean, this is sort of the conundrum for us. And I'll and jump in if I'm telling it wrong, but started to engage with child pornography and was charged. And
Yep.
I believe was incarcerated or was pre-trial, and started to then walk with a limp and display other
Yep.
symptoms. They realized he had a massive growing brain tumor. Yeah, and they removed the brain tumor and the symptoms abated.
Totally went away.
Yep.
And then slowly the tumor came back and so did the symptoms come.
came
Yes.
And so the question is, and there's actually Alan Alda has a whole sort of thing, sort of a thing on neuroscience where he talks about it. But the question for all of us and for the system, and to me, we can say it's not blameworthy, right? I mean, it is
A physical change.
Well, it's
Yep.
not about agency. It's something organic that's causing it. But then the flip side is, but he's dangerous.
Yes.
And so what does the criminal justice system do?
And how do we rectify
Yeah,
that?
and it's, as a defense attorney, I mean, I come up with one answer, which is, well, the response to, perceived dangerousness that's organic is not to put someone in a cage where it manifests, et cetera.
Yes.
But, this is a perfect distinction between how the supervised release board might treat these questions and us. They don't have sort of the discretion to kind of say, we're actually worried about justifications for punishment writ large, what our role here is, and whether we're, perpetuating an inappropriate response to what it is we see. But that doesn't solve what happens when this person leaves.
Yes. Or if this comes back again and they become a danger to others.
Exactly.
Yeah.
And so, is it realistic that people with TBIs may, run afoul of the law more often than those who don't have them? Yeah, just as it is that kids are going to run afoul of the
Yep.
law, right? So, I mean, one of the main questions for us is, can we overlook signs of risk, recidivism, when we understand, their core, even if we can't be part of the solution? I mean, can we still say, this isn't a perfect solution, but we know they shouldn't be in prison?
Yep.
So, I mean, I think that's our query.
I'm so glad you bring up that point. That's a super interesting case study that I like to refer back to.
Yeah, yeah. And I'm not sure I had it exactly right, but that's just a bit, yeah.
That's pretty much how I remember it too.
Commissioner Roller, I see that you are unmuted. Do you have a question or comment?
No, I just wanted to say thank you for calling out the effects on domestic violence survivors. Is something that we've known for a long time. There is a lot of brain injury that happens during those assaults and violence, and how they show up and tell their story. It's also important and something that we need to take in consideration as a commission as well.
Absolutely. Well, thank you guys so much for having me. What a pleasure.
Awesome. Thank you so much for coming.
Really, really well done. Can we have access to the PowerPoint?
You got it. I'll send that your way.
Great, thank you.
Thank you, everybody. Thanks for our folks on the Zoom.
Yeah.
All right, thanks everyone for being here. I will figure out some date for the lunch meeting before July so we can talk about that, and you can still have enough time to review for the July meeting. So
Thank you.
Well, we've made it through the end of the day. We went a little bit long, but that's all good. Appreciate everybody being here today, and we can be adjourned, right?
yeah.
We're adjourned.